item number 37 in order column. On 16.5, my lord, while moving the motion, my lord has indicated to dispose the matter by passing an appropriate order. In 37, is it possible to upgrade the notes?
We'll take it up, don't worry.
Okay.
They just stay.
No. So for the landlord tenant case, my lord, so justice service has been completed.
We'll see when the matter.
Right.
My lord, two MSc appeal, my lord. Two MSc, that two appeal was listed, my lord, on 2022, my lord. Thereafter, not being listed. It may be listed, my lord, in order.
It should come up for what?
Orders, man. Obliged.
My lord, I am praying for one listing for withdrawal of the second appeal matter. Though it is in hearing stage, but for withdrawal, my lord.
Okay. Tomorrow?
Today, can it be possible today?
Okay.
Once.
Then let it come up tomorrow.
Yes.
May your lordship. In item number 25, your lordship, we have filed our affidavit in opposition. I pray that same may be tagged.
Obliged. I beg to pray, my lord, one item number 13, my lord. The arguing counsel, my lord, his premises is now under water, my lord, waterlogging problem, my lord. So he could not come today, my lord. He is the arguing counsel, CM Mohanto. So
You do it.
Pass over for the day, my
You
lord.
do it. Your name appears.
My lord, see, I can argue, but because of
Not
file, my
necessary.
lord.
Next.
Because of file, my lord, I can.
May I please your lordship?
If you don't have a file and you have put your name out there, it is shameful.
No,
Mr.
no, my
Pradhan.
lord, he is the arguing counsel, my lord.
So what? Where did you put your name at all?
My lord, I will agree.
May I please your lordship? Lordship, RFA of 22, lordship, lastly posted on 12/12/2024. Hence, lordship not listed for order matter on 13/6. Order for orders, lordship.
Why?
Lordship, lastly listed on 12/12/2024. We are
For what?
directed to take steps upon the respondents, lordship.
You have taken steps.
Lordship.
Service is complete.
Lordship, for order matter, it may come on 13/6. Highly obliged, lordship.
When will?
13/6, next week, lordship. Next week,
13.
13/6, lordship. Lordship. Highly obliged.
Can it be day after, my lord?
May please your lordship. Lordship, on item number 5, we have filed an additional affidavit. It could maybe tagged along.
For motion, item 1. Item 1.
Yeah, please, your lordship. So my senior engaged counsel is on the way. He has been facing some waterlogging problems. So he's on the way. I kindly request you to take the matter up to some.
You have not filed the additional affidavit.
My apologies, sir. I request you please.
And we'll have it after 4 weeks.
All right.
Taking into account the additional affidavit has not been brought on record. And in terms with the order dated 23/7/2024, this will matter 4 weeks.
Item 2.
My lord, there is a case. Respondent number 3 has already expired, and for that we have already filed one petition for substitution on 10/4. But that is not
Very
coming in record.
challenging.
That is not in record.
What are you challenging?
Challenge, my lord. One of the defendant had expired, and for the petition was filed for his substitution. The opposite party, defendant also had not objected, but the landlord Munsif rejected the petition, saying that it is not in proper form.
Which order are you challenging?
Twelve 6/24.
Who died? Who died?
Reference number 6.
Why are you making the respondent number 6 a party?
Defend number 6, but had expired.
Understood. Why you are making at page 7? Why you are making a dead person a party?
My lord,
Isn't Srimati Nirudas dead?
I had filed petition for substitution
Understood.
and that was not objected initially. But the landlord rejected petition saying that it is not in proper form. Then I
Mr.
filed-
Counsel, isn't Mrs. Nirudas dead?
Yes,
Then why you are making her as opposite party in the instant press application?
no, she is not the opposite party in this.
Kindly come to page 7.
My lord, against her, the suit has abated and
So therefore, are you going to make us, whom should I issue notice? How do I effect the service upon a dead person? Tell me.
maybe allowed
Mr.
to correct.
Counsel, withdraw this petition. File a fresh one, wherein you make, instead of Nirudas, her legal representatives as a party. That is what you need to do. How can you, whom should I issue notice? I can't issue a notice upon a dead person. Yes, that order is palpably wrong. There's no quarrel with that. But what you have done is making that person only a dead person only a party here. Mr. H.L. Moria, the learned counsel submits that he may be permitted to withdraw the instant petition with the liberty to refile, taking into account that inadvertently the inadvertently the opposite party number 6 with the defendant number 6
My
have
lord,
been
may I say one thing, my lord? I did not make them party because my petition for substitution of their legal heirs was rejected. That's why I did not make a
You-
party.
Therefore, what you are required to do is to file an application making them a party,
Yes,
isn't it? So you have to make them a party. They have a right to say. Then only I can affect it. In fact, you don't require the others. Who are you are the plaintiff.
yes.
And who are the other defendants? Where is the suit?
At page number 33, 32. And meanwhile, number 3 has also expired.
Wait. Wife of Windows property. You have to make either Gautam Das as a party or her sons. File that petition properly.
And meanwhile, number 3 has also expired during
Who?
pendency of this petition.
Hiren Chandra Das.
Yes,
Okay.
and for
No,
him,
for that it is okay. You have to make them also separately.
for them, I filed one petition also that is not come in record. And in the trial court, we have already filed petition for his objection.
Now you file a composite petition now, making them a party.
Legally supported.
Yeah, that during the pendency they are expired and as such they are made the respondents. And in the meantime, you file also an application before the trial court against the defendant number 3.
That we have already filed.
As regards defendant number
Yes,
3, you
we
have
have already
filed.
filed.
Mr. H.L. Moria, the learned counsel submits that he may be permitted to withdraw the instant petition, taking into account that inadvertently the opposite party number 6 have been made a party against who had already expired. So he therefore submits that he may be permitted to refile by removing that formal defect. Taking into account the above, the instant petition stands closed, liberty given to the petitioner to refile by removing the formal defect.
Item 3.
That respondent number 1 is plaintiff had filed a suit, my lord. In the suit, the plaintiff's case is that the plaintiff had entered into an agreement for sale with the petitioner in the year 2008. That was in respect of 17 acres of land. And while entering into the unregistered agreement for sale, the one person was there in that plot of land. Subsequently, in the year 2009, the plaintiff has purchased the possessory right in respect of that land. And thereafter, the plaintiff, after taking the possession, have come to know that there is 13 acres of land. Now, subsequently, the petitioner, the defendant number 1 has entered into an agreement, registered agreement.
So your ground is on what? Order 7, Rule 11?
On limitation, my lord. Because for a moment, if your lordship, my lord, of the plaint, if your lordship comes to page 62, my lord, the plaint starts from page 58, my lord. I'm referring to 2 pages, my lord, page 62, my lord.
You are the defendant number?
1. I am the landowner, my lord. Second paragraph, it is pertinent. What you got it, my lord? It is pertinent to mention herein that in the said agreement for sale dated 28/12/2008, it has been mentioned that the entire plot of land comprised in Dag number so and so of land measuring 17 acres is under possessory dispute, and the same was under illegal occupation and possession of Sri so and his wife so as per his own admission of the defendant number 1. Within this, wherein they had been illegally residing in assembled house bearing number so and so. After the said agreement dated 28/12/2008, the said illegal possessors had also agreed to vacate and hand over the exclusive physical possession of the said plot of land and construction standing thereon to the plaintiff by entering into a notarized deed of sale for possessory right, being instrument number so and so. This was in 2009, my lord. Dated so and so by receiving 6 lakhs in cash as per consent of the defendant number 1. In both the aforesaid agreement for sale dated so and possessory right dated so and so, the land proposed to be sold and delivered, the possession has been shown as 17 acres covered by PP Patta number so and so. But after taking over the possession of the same, it was measured by the plaintiff in presence of the defendant and found actually that the land proposed to be sold to the defendant number 1 and handed over by over the possession of illegal occupiers is only 13 acres. The lordship will come to page 64, my page 64, para 6. Para 6, my lord. That by clause 3 of the said notarized agreement for sale dated 28/12/2000.
Your simple case is, let us not go 2008 agreement.
Yes, my
There was a sale permission in 2012.
Yeah.
And thereafter, in 2023, the suit was filed.
It was filed. Now, in para, my lord, 6 at page 65, my lord. Page, if your lordship kindly turn to 64, para 6, my lord, 4th line from bottom, accordingly. Accordingly, since after the said agreement for sale dated so and so, repeatedly the plaintiff and her husband had requested the defendant number 1 to obtain the requisite sale permission in respect of the below scheduled plot of land and structures tending thereon for execution of the final sale deed in favor of the plaintiff. This is important. But the defendant number 1 had, although obtained sale permission dated 12/3/2012, but not in respect of below scheduled plot of land and structure standing thereon, and rather in respect of other land fraudulently in illegally, due to which proper sale deed could not be executed in favor of the plaintiff. Now I will pause here for a moment. So my respectful submission to your lordship is that, my lord, as he has pleaded that he came to know that in the year 2012, the landowner, that is the petitioner, had fraudulently and illegally obtained the sale permission. So that means in 2012, he had the knowledge about non-performance because Article 54, my lord, of the Limitation Act suits for specific relief act, my lord, enforcement limitation is if, my lord, the time is fixed, then within that time, and if no time is fixed, when he had the knowledge of refusal. So in 2012, he had the knowledge of refusal. And thereafter, what is the pleading, my lord? Since thereafter, that means after 2012, I am reading page 65, my lord. Since thereafter, all along the plaintiff and her husband went on requesting the defendant to apply and obtain for sale permission for the sale of below scheduled plot of land and structure standing thereon in favor of the plaintiff in due performance of the agreed terms and conditions of the said agreement for. And upon all their requests, the said malafide criminal cheater defendant number 1 had avoided the request. Now 2012, my lord, he came to know that he has not performed. After 2012, he had been requesting, my lord, 2012 to 2022. My lord, if he has requested 12, my lord, 3 years will go in 15. So the main contention is, and further, my lord, and down below, he further states that, my lord, 1, 2, 3, fifth line, further till date, page 65, my lord, further till date, the defendant number 1 has neither in writing nor verbally denied the performance of his agreed part of the contract. Now, if that be the case, my lord, that means, my lord, this case is a premature one. So, agreement of 2000, my lord, 8, he says that in 2012, the sale permission was obtained in respect of another land. And he specifically says that, my lord, fraudulently and illegally. So that means he had knowledge that the defendant is not willing to perform his part of the contract. And where is, my lord, the readiness and willingness? From 2008, he has been sitting there. And
Possession has been delivered.
possession has been delivered.
You.
Yes, possession has been delivered. Now, if the possession has been delivered, his prayer is also for confirmation of possession. Now, in this context, my lord, my respectful submission would be the relief for possession of confirmation of possession is a subsequent relief, is ancillary relief. The primary relief is that specific performance. Now, if he succeeds in specific performance of contract, then only, my lord, this relief of confirmation of possession will come. That apart, my lord, if when he has sought for section 17A.
Mr. Counsel,
Lordship, to this application, I intend to file affidavit.
Why?
To bring on records the facts and other things on.
Mr. Counsel, we need only 2 documents, which is already there on record. One is the agreement,
Lordship,
second is the plaint. We don't require to see any other document. The agreement categorically mentions that he will sell you a particular plot of land for a permit for a value of rupees 4,50,000. Okay. Permission was to be obtained by him
Lordship,
at your post.
Lordship.
Now, there is no period mentioned in the agreement. So, Article 54(1) part, first part does not come into picture. Second part comes into picture. Now, if his second part comes into picture, where is your statement after 2012? Forget about the other things, what he has said about paragraph 6, 7. After 2012 till 2019, 23, where is your statement in your plaint?
To the respect, Lordship, I beg to mention, Lordship, page number 69 may come up.
Huh?
Page number 69.
Yes.
Para number 10.
Hmm.
And it is pertinent to mention herein that in the agreement for sale dated 28/12/08 of the plaintiff, the defendant number 1 has shown the structure and house standing thereon, which is demarcated by this. Lordship, next page make time. Lordship. Yes, Lord. This top from fourth line also. Hence, on and from the perusal of registered agreement for sale 18/7/23, which the defendant number 1 had agreed to sell to the defendant number 2, Lordship. The intention of the defendant number 1 becomes transparent and clear enough that he is not having any such bona fide intention to perform his part of contract in favor of the plaintiff in terms of unchallenged and undisputed agreement for sale 2008. So this cause of action has arisen on being, Your Honor, we have come to know as regards execution of agreement for sale 18/7/2023.
Your case comes strictly within the purview of a judgment of the Supreme Court in the case of Partition.
2015.
2000,
2015, my lord, 8 SCC 390.
kindly give it to him. Paragraph 6. Isn't it?
Yes, order.
And paragraph 7,
Hmm.
question of possession.
Position
question.
is there.
So far as Lordship. Now, Lordship, I would bear one judgment of the Honorable Apex Court recently, Your Honor, in respect, Your Honor, that is passed on May 23, 2025.
What does it say?
It says, Your Honor, Lordship, that the appellant relies on the decision of in the court in Central Bank of India versus Probate, which holds that even if one cause of action in a plaint survives, the entire plaint must be tried. So, Lordship, in this. So, Lordship, he has come up in respect of agreement for sale for 2008 and thereafter till 2023. After obtaining of sale permission, there is no cause of action, he is trying to sell it. So my objection may kindly be seen on Lordship.
No, I am on the question. Are the other not reliefs which you are claiming based not on your agreement for sale?
Lordship, yes.
Now, if you cannot seek for specific performance, other reliefs goes.
Definitely.
Now, if we take section 17(1)(a)
Yes.
of the Registration Act, your agreement is only notarized.
But Your Honor, that cannot be ousted on Lordship only on the basis of that is notarized one.
What?
Cannot be ousted because that is only notarized one. Lordship, 17. Your 2018-7 SCC 639 specifically says, Your Lordship, that in case of contract of sale, Your Lordship, registration under section 17 is not mandatory.
Oh, Mr. Counsel, that is for a contract for sale.
Now, this is a
But
contract.
no, I am asking you, if you are claiming possession on the basis thereof, that
Let-
you should not be ousted, that means you are claiming certain possessory right under 53A. Now, can you raise that issue? Taking into account section 17(1)(a) of the Registration Act.
Can it be taken tomorrow?
Why?
I will, Your Honor, satisfy on.
No, you cannot satisfy this court. Your
Tomorrow?
case is horrendously time barred. We stay. We stay these proceedings. These proceedings cannot, it's an abuse of the process. Is there an injunction?
No, Lord.
If it was an injunction, I would have finished it today itself. Issue notice, why do you need the performer respondent?
Not requirement because he is the main person. Caveator is the main person. Even the presence of
Issue
performer is not
notice,
required.
making it returnable on, will give you ready, make you ready very much. On 6th of August 2025. Steps be taken upon the respondent number 2 by way of registered as well as usual. As regards to respondent number 1, Mr. So-and-so appears and accepts notice as he is already on caveat. The revisional jurisdiction of this court has been invoked, challenging the order dated 18/3/2025, passed in Mize case number 1164/2023, whereby the learned court of the Civil Judge Senior Division number 1 Kamrup Metro at Guwahati had rejected the application filed under Order 7 Rule 11A and B for rejection of the plaint. First, Mr. A. Das, the learned counsel appearing on behalf of the petitioner, submits that the agreement for sale was entered into on 28/12/2008 for sale of a plot of land at measuring 17 lechas. Although the agreement for sale does not mention the date fixed for performance, but the clauses mentioned therein would show that how the performance is required to be carried out has been duly mentioned. Referring to clause 3 of the agreement for sale dated 28/12/2008, the learned counsel submitted that what is required, that as per the agreement, the petitioner was to obtain the requisite permission at the cost of the respondent number 1. And thereupon, after obtaining the permission, the deed of sale is required to be executed in favor of the respondent number 1. The learned counsel submitted that as obtaining a permission is one of the requisite for sale of the land as per the terms of the agreement for sale dated 28/12/2008, the permission having not been obtained as have been admitted by the plaintiff in the plaint at paragraph number 6 clearly goes to show that the plaintiff had noticed that the defendant number 1 have not taken steps for the purpose of obtaining the permission. The learned counsel further submits that the plaint is completely silent as regards the period from 2012 to 2023. Referring to the judgment of the Supreme Court in the case of Partition and Company versus, what is the name?
LM Nagpal and others.
L.N. Nagpal and others reported in so-and-so. The learned counsel submits that the instant case squarely is covered by the judgment of the Supreme Court in the said judgment. And as such, this is a case where this court ought to exercise the revisional jurisdiction. This court have also heard the learned counsel appearing on behalf of the respondent number 1, who is the plaintiff. And The learned counsel submits that he required some further time to address this court. This court, having perused the plaint as well as the deed for agreement for sale dated 28/12/2008 and the judgment in the case of Fateji and Company, Supra, is of the opinion that the petitioner herein have been able to make out a case for stay of the further proceedings of title suit number 574/2023. Accordingly, the further proceedings of title suit number 574 of 2023 pending in the court of the Civil Judge Senior Division number 3 Kamrup Metro at Guwahati shall remain stayed till the next stage.
I'm deeply aware.
Caveat stands discharged.
Item 4.
We thought discharge koi libo, huh?
Please, your lordship. Your lordship, as per order dated 6/5/2025.
Oh, this case.
Yes, we have.
Did you
received
bring
the
it?
copy. We have received it.
Where is it?
Your lordship, this is for your lordship perusal.
Huh?
The order sheet.
By way of an IA? What is this IA business?
We don't have any IA, this is PRP IA.
Okay.
That flag mark is the, from that the relevant portion will start. 25/10/2020.
Yes. Without the bill. Oh. $27,500.
27/5, now the next date is 27/6.
Okay. So the suit have not further proceeded.
Yes.
Now, what is your case?
Your lordship, as per that impugn order, which is at page 31.
Page?
Page 31. Page 30 in fact. Lordship, their petition under order 7 rule 14(3) that has been allowed by the defendant. Now that has been allowed, your lordship will find after a period of 14 years. And the next page, your lordship will find in the first paragraph, they have also been allowed to re-examine the PW1.
Then
Your lordship will find that petition under order 14.
why didn't you file an objection?
That we did not file.
So,
But your lordship, whether this kind of petition can be allowed after a period of 14 years, that too when they could not exercise due diligence, because they were knowing about those two documents which they want to bring on record, which they have admitted in their petition at page 62.
here the court have exercised the power on the order 18 rule 17.
Yes, whether that can be allowed, your lordship, at this stage.
Why?
Because that will amount to filling up the lacuna. Because this defendant one.
Are these deeds not important?
Is important, but that was already there in that evidence. They have admitted these two sale deeds. That is sale deed number 749 and 950 of the year 2005. That was already admitted in their evidence as well as the plaint. The lordship will find the.
But they did not bring in.
But they did not bring it.
Now
But
they
that
want to
was-
bring in.
Now they want to bring it. That was
Okay.
already in their.
You
knowledge.
cross-examine them.
There is a lapse of 14 years. Huge delay.
You see, the court had exercised the power under Order 18/17,
Yes.
and the court feels that these two documents are essential. Is it so shocking that this court should interfere?
But before that, we had
Because
also,
Mr. Counsel, first you have to understand, I am not sitting as an appellate court. So it is so shocking for this court that we should exercise 237.
there is one decision
Yes,
by the-
please.
passed by the apex court. Lordship in 2009 4 SCC 410.
What is that?
That the power of relief that can be that cannot be granted at this stage. It has to be exercised sparingly. So your lordship will find page para 25, the relevant portion. Though the provisions from the of Order 18 Rule 17 have been interpreted to include applications to be filed by the parties for recall of witness, the main purpose of the rule is to enable the court, while trying a suit, to clarify any doubts which it may have with regard to the evidence led by the parties. The said provisions are not intended to be used to fill up omissions in the evidence of a witness who has already been examined. Now 26, as indicated by the learned single judge, the evidence now being sought to be introduced by recalling the witness in question was available at the time when the affidavit of evidence of the witness was prepared and affirmed. It is not as if certain new facts have been discovered subsequently which were not within the knowledge of the applicant when the affidavit evidence was prepared. Exactly this case here. In the instant case, Sadanand Sheikh was shown to have been actively involved in the
Come to paragraph 30.
30. Of course, if the evidence on re-examination of a witness has a bearing on the ultimate decision, that reason has been. It is always within the discretion. Yes, discretionary power is there, of course. To permit recall of such a witness for examination with permission to cross-examine.
And Mr. Counsel, you have also to understand. Here is a case the court did not permit.
Yes, here the court did not permit.
So therefore, when you are challenging that, it's a different aspect, ball game. You didn't file an objection, you did not contest there.
But
You are happy
similarly,
now.
your lordship,
At
we
the
also-
end of the day, isn't the truth the guiding star?
that is,
So if that is there, why not? If this document is there, it's okay, but there should have been some imposition of cost. Isn't it? Now he will be coming for re-examination. You will have a right to cross-examination. We only say here, without affecting this order, we say that okay, but if the witness come, they will have a right of cross-examination. That's all. Heard Mr. S. Dr. the learned counsel appearing on behalf of the petitioner. This is an application file challenging an order dated 30/9/2024 passed in Mize case number 269/2024 arising out of title suit number 33/2010, whereby an application file under Order 7, Rule 14(3), read with Section 151, was allowed by the learned trial court, thereby granting leave to adduce, to bring on record, to adduce evidence in respect to the sale deed number 749 dated 5/8/2005 and sale deed number 950 dated 13/12/2005. Full stop. This court finds it relevant to take note of. That at paragraph number 5 of the plaint entitled suit number 33/2010, the plaintiff had duly mentioned about the registered sale deed number 749 dated 5/8/2005, as well as the registered sale deed number 950 dated 13/12/2005. Whereby five. It is also seen that the plaintiff have claimed their title on the basis of the sale to deeds of sale, isn't it?
Yes.
And you have not denied those sale deeds.
We have denied, Your
No.
Lordship, in a written statement.
No. You have not denied.
Denied some.
No.
At para 16 of the
Para?
WS, para 16 of the WS, page
Yes.
42.
What does it say?
That Fatima Mazumdar was not having any right title, interest, possession over 12 kathas of land covered by so-and-so dag number or any other land on the said patta pursuant to such illegal purchase. The vendors of the plaintiff, Rune Roy and others got municipal holding number so-and-so on the unassessed land, suppressing the real fact and subsequently the
Where
plaintiff.
you are denying?
We have said that this is an illegal transaction,
You have not even specifically mentioned that these are illegal.
but the entire transaction we have said that it is illegal.
However, in the written statement filed by the defendants, by the petitioner, defendants who is the petitioner herein, there is no specific denial as regards the existence of the said deeds of sale. It is seen that at the stage of arguments of the suit, an application was filed by the plaintiff under Order 7, Rule 14.3, read with Section 151, seeking leave to produce additional documents. At paragraph number 3 of the said application, it was stated that the said deeds were not produced in the course of the proceedings, presumably due to oversight of the then engaged counsel. And the said deficiency was only discovered by the newly engaged counsel who had entered appearance on behalf of the plaintiff. By the said application, the respondents, the plaintiff therefore sought for leave to adduce evidence of the said two documents, deeds of sale, by re-examination of PW1. These facts which were stated in the application were not denied by the respondents, by the petitioner, who are the defendants in the suit, by filing objection, although they duly received a copy of the said application filed on 9/8/2024. It is further relevant to take note of that the learned trial court had granted them the opportunity to the petitioners to file objection on 30/8/2024. And on 11/9, 30/8/2024. On 30/8/2024, the petitioners, who were the defendants, did not file any objection. And it is under such circumstances, the impugned order dated 30/9/2024 was passed, whereby the learned trial court allowed the said application filed by the plaintiff It is under such circumstances the present proceedings have been filed. This court have duly taken note of that the learned trial court though was adjudicating an application under Order 7, Rule 14.3, but in fact, the order so passed was in terms with Section 151 of the code, taking into account that what the learned trial court permitted was allowing the applicants plaintiffs to adduce additional evidence. First, this court have also taken a note of the grounds assigned by the learned trial court in its impugned order. And thereby allowing the said application. The allowing of the said application, the grounds so assigned by the learned trial court does not shock and surprise this court to exercise the supervisory jurisdiction. Be it as it may, as this is not a case by which the court had exercised the powers under Order 18, Rule 17 for recalling a witness, but rather it was a permission being granted to adduce additional evidence under Section 151 by the learned trial court. The learned trial court ought to have also mentioned that the defendants would have a right to cross-examine the plaintiff witness, as well as also give rebuttal evidence. Accordingly, this court, without interfering with the impugned order dated 30/9/2024, passed in Mize case number 269/2024, arising out of title suit number 33/2010, observes and directs as follows. Number one, the order dated 30/9/2024, passed in Mize case number 269/2024, passed by the Learned Court of the Civil Judge Senior Division number 1, Kachar at Silchar, shall be treated as an order passed in exercise of the powers under Section 151 of the Code, thereby permitting additional evidence to be adduced by the plaintiff. First, number two, if such additional evidence is being adduced by the plaintiff as per the permission so granted by the order dated 30/9/2024, the defendants who are the petitioners herein would have a right to cross-examine. First, in addition to that, this court further observes and directs, in addition to that, the defendants shall also have a right to give rebuttal evidence. First, this court have been duly informed next that the next date is fixed on 25/6/2000, 25/6, 25 or 27? 27/6/2025, before the Learned Trial Court. A certified copy of the present order be placed before the Learned Trial Court for further proceedings of the suit.
Obliged.
I disposed.
Item 5,
directed us to file an additional affidavit. We have filed the additional affidavit to bring the orders passed subsequent to the passing of the impugned order on record, Lordship, at page 34, annexure 5.
What do you want? Not interested in an early resolution.
That Lordship,
Well, not interested.
that Lordship,
There is no mention
have
in the
already
petition what happened on
replied.
5/3, which was the date fixed for defendant evidence. You have filed an additional affidavit.
yes,
Good.
three
What
orders are
happened?
passed.
5/3. Both today is fixed for DWs, if any argument, defendant side has not filed any further DW. The learned counsel for the plaintiff has filed a petition to adjourn today and fix another date for the same as the plaintiff is willing to prepare a revision against the order passed by the appellant, Iman, or further DWs, if any, oblique arguments. 25(6). Advocate has filed a petition praying to adjourn the case today and fix another for the same if the plaintiff is willing to prepare. Prayer is allowed. Why the trial court allows this type of prayers like this? I think this is the fifth case where I should pass an order, make it clear that merely filing a petition would not do. The court has to get a stay order. You have also said a certified copy of an order means a dismissal order. Has filed a petition praying to adjourn the case today. Yeah. Then what happened on 21/5?
21/5, next date is fixed on,
For judgment?
next date is fixed on 18/6/2025
For?
for certified copy of order and argument.
Okay, now argue.
This case, Lordship, will have a look
What
at
are you
it.
challenging?
Challenging is to the dismissal of my petition under section 151,
For?
whereby, Lordship, what has happened, Lordship, the plaintiff has adduced its witnesses, those were cross-examined, and defendant side, Lordship, already adduced 2 witnesses. And when the third DW was filed, Lordship, DW3 sought to bring certain documents on record, which were not even exhibited by the principal defendant. So we filed a petition for de-exhibiting those documents, Lordship. And Lordship, the impugned order is passed on 25/2/2025. Our prayer was that the documents which are sought to be exhibited should be de-exhibited. The learned court is of the opinion that there is no provision of law under the law for de-exhibiting any document, and any it will be open for us to put any relevant questions during cross-examination to question its admissibility. And simultaneously also the cross-examination of DW3 was also closed.
Because you did not cross.
That, Lordship, question was posed to the counsel there. And
It is written, the plaintiff side on
he-
being asked plainly refused to cross-examine the
That-
heir who is present before the court on the 4th occasion.
that was a lacuna on the part of the counsel, Lordship.
Then, have you filed a bar council complaint?
That-
Have you?
No.
Then? So you got the
only-
suit.
Only difficulty is that, Lordship, my,
Who filed the petition asking for de-exhibiting exhibit 4 to saw?
yes,
Who filed? You.
the DW, the defendant file.
Was that allowed?
And the plaintiff
Was the plaintiff application allowed? That was also petition was rejected.
petition was rejected.
Then?
Now, learned trial court is the opinion that I will get an opportunity to cross-examine, Lordship. And on next date ought to have been fixed for cross-examination, Lordship,
For?
after disposal of the petition for cross-examination.
You were asked to do it. Plaintiff side on being asked plainly to hear. So you mean to say the court passed this order and then asked you, or prior to that?
No,
So you want
The
to cross-examine DW3?
petition was rejected and
Mr.
thereafter,
Counsel, you want to argue, cross-examine DW3?
that is the only prayer. At least,
Issue notice making it returnable on 25,000, cost upon the respond number 1 and 2. Steps be taken by issue notice returnable on 23rd of June 2025. Steps, what the next date is?
next date is 18/6.
We have it before. 16/6,
Lordship,
16/6.
16/6.
Finish it off. We'll allow you. Notice making it returnable on 16/6/2024-25. Steps be taken upon the respondents by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. The petitioner herein have assailed the order dated 25/2/2025, whereby the learned court of the which court? Civil Judge, Senior Division, Golaghat,
Senior Division Golaghat.
had deprived the petitioner, who is the plaintiff in the suit, to cross-examine the DW3. Had barred the petitioner, who is the plaintiff in the suit, to cross-examine the DW3. Counsel appearing on behalf of the petitioner submitted that as 25/2/2025 was the date fixed for passing of an order as to whether order in the petition number 737/25 filed by the you filed the petition.
We filed. Petition was filed by the plaintiff.
When did you file that petition? On that day? Oh, on that day?
Yes. Yes, on that day.
And the court must have said nothing doing. I'm
Nothing
dismissing
doing.
you, I'm asking you to
The
proceed.
defendant side also did not file any written objection. They were
Not
heard ordered-
necessarily on that day, only the court disposed.
Yes.
Submitted that the petitioner has filed an application seeking a direction for de-exhibiting exhibit core to saw submitted by DW3. Full stop. The learned counsel submitted that without an adjudication of the said petition, the question of cross-examining the DW3 did not arise. However, the learned trial court, by the impugned order, not only rejected the said petition, but also debarred the petitioner, who is the plaintiff, to cross-examine the DW3. He therefore submitted that as regards the order, impugned order, he therefore submitted that this court ought to interfere with the order dated 25/2/2025 insofar as debarring the petitioner/plaintiff from cross-examining the DW3. This would have taken an anxious decision on the matter, and that this court having heard the learned counsel is of the opinion that without there being a decision as regards the petition filed by the petitioner for de-exhibiting exhibit number core to saw,
Petition was rejected.
the learned trial court could not have allowed the plaintiff to cross-examine the DW3. First, this court duly takes note of that the learned trial court on the day on which the said petition had filed had rejected the said application. Taking into account that the order was passed on the same day, It is the opinion of this court that the learned trial court ought to have granted a further opportunity. In that view of the matter, this court prima facie is of the opinion that the learned trial court had erred in exercising its jurisdiction. Consequently, it is the opinion of this court that the petitioner have been able to make out a case for stay of further proceedings of title suit number, what is the number? 2/2021, pending before the court of the learned civil judge senior division Golaghat in the next state. Accordingly, further proceedings of so and so shall remain stayed till the next. 16, get ready with 35,000. 10,000 additional
16,
for
what
the
should be
passing of this.
16.6.
16.6. Don't expect that on 18. 18th you cross.
Item 6.
We are ready to cross.
You will cross on that with 35,000 deposit. And if you don't take steps, I'm vacating
no.
this out.
We are going to take steps today.
Yes, what is Assam Tribune doing here?
Make please, Your Lordship. My lord, the impugn order is that
Page
page
26.
26.
Yes, what is this?
My lord, what happened, my lord? The suit was proceeded ex parte against the defendant, sole defendant. And I
Who is the
filed,
sole defendant? You are.
I am the plaintiff. I have filed this suit for recovery of 16 lakhs and odd, my lord.
Then
And then what happened, my lord? I filed one application under section 65 of Evidence Act for giving secondary evidence. While allowing my my application, the court at the last paragraph, my lord. Therefore, considering the all the aspect, this court finds it justifiable that prior allowing the plaintiff to edit secondary evidence in Exhibit 4 to 11, plaintiff should be directed to take steps upon the defendant for production of original Exhibit 4 to 112. But when the suit proceeded ex parte, this order issuing notice under section 66, in my opinion, man, as per my understanding, it's not called for, man. And kindly pay this on this, my lord. Section 65 of Evidence Act is a directory in nature. My lord, in Dhanpat case, my lord, that was read, my lord, at paragraph 22, my lord.
so you will be permitted to use secondary photocopies. Because the defendant is proceeding.
He opted not to contest the case. So I may be allowed, my.
So you don't have any other document?
My lord, I have Exhibit 4 to 112. These are the bills, my lord. My lord, what happened, my lord?
Who gave the bills?
My lord, the defendant requests us to give some publication. Publication of advertisement. Accordingly, advertise that, and after advertising that, my lord, that copy of the paper along with the bill and his requisition, these are sent to him, handed over to him, my lord. So this is the case, my lord. And in that procedure, total 16 lakhs and odd, he is not paying. That's why we filed the suit. He appeared in the case, my lord. Thereafter, it got expired. He opted not to contest, man.
Where is it? What are you referring to? Section 6?
My lord, in the judgment, paragraph 22, my lord.
There is no requirement that an application is required to be filed in terms of 6 months before secondary round. Parties who are least may choose to file an application. How is this relevant?
Directory in nature, that's.
No, this is on another thing. Sometimes what happens, a person may not file this application. But if you have laid the foundation in your plaint or even in the examination in chief, then you need not file a specific separate application. This is what it means. But what you are trying here is a different case.
My lord, when the.
You should notice to him prior to that. And this, what is being directed is, we have issued this, kindly produce this document, we require it. That's all, you are required to do that.
But when the proceeding, the case is proceeded expertly.
So why do you want this original, but then can you allow the court to take into account photocopies? That's no evidence.
Only newspaper cutting for photograph, other are original. My original bill,
So original bid, you will have copies of it.
yes, that
So those copies will be there, so you have to mention that these are copies of the original bids which have been sent to him. Why do you want the original of them to be produced, the photocopies? If you already have that.
the advertisement is not with me, my lord. The paper cutting,
So you did not advertise.
I advertise.
Then why it is not there?
Only photocopies remain. I leave it to your lordship, man.
No, you don't leave it to me. But what the court has directed is right. And you should not have taken all the pains of going for all these things. What you were required to prove is only a prima facie case. And for that you had the advertisement. I think you should take steps. Let them come back. You have, to
I'll
issue,
do that.
you have to issue him only a notice that look here, these are the documents which we have sent it to you. Kindly produce this thing as it is required. They come very good. You don't want to fight with him. You
I'll
don't
do
want a
that.
fair fight.
I'll do that.
Mr. G. Boisho, the learned counsel appearing on behalf of the petitioner, submits that the plaintiff would take due steps in terms with the order and as such would not like to press the instant petition.
All right.
Supplementary item 42.
Yes, what is this?
Look here. An amendment was allowed at the stage of SBPH, but
Huh?
the suit was originally a suit for specific purpose of contracts.
Which
Look.
order?
Also will find it at page 42. Order dated 20/12/2024.
Do you know why I did not dismiss on that date? This one, I would have dismissed. Your junior escaped without saying that he did not have the brief. I said, okay, let it be in the hands of his senior.
No, otherwise he is senior to me,
Senior in experience in civil law. Let it be in the hands of his senior. What is
The
that?
only thing, Lord, you will see. I'll just take it it was basically a case of under the specific purpose of contract. The claim was that when an agreement was executed between the parties, 95,000 was paid, 5 lakhs was to be paid at the time of execution of the deed. We came up, the written statement was filed. We took a stand that no, he was a petition writer. Documents were given to him for the purpose of obtaining a sale permission. He converted those documents, he manipulated those documents, executed an agreement, as well as he took permission.
What was the stage of the suit?
It was in the stage of SBPH. Now, Lordships, what has happened?
So
is-
was new persons added?
Exactly, not only that.
No, Mr. This order was preceded by an order passed under Order 1 Rule 10.
In the same order, yes.
What same order?
Same order. In the same order, this was taken into account, my lord. There was no petition filed under Order 1 Rule 10.
Ah.
Page 43, if your lordship kindly comes. Third paragraph,
Page?
43.
Yes.
At the very
Now,
outset,
upon
let me
perusal of the, it appears that the amendment as sought by the plaintiff becomes relevant in view of the addition of the new parties.
Yes, my lord, 43, my lord, page. There is no application. The court can, my lord, under Order 1 Rule 10, my lord, yes, the court has the power to add parties. I'm not
Ah.
saying that. Now, lordship will see. Now, at the very outset, let me report this. Lordship, page 43. Lordship has got it. Order 1 Rule 10(2) of the CPG, which provides under, that is not been quoted. Now it appears to me that the interest of justice, the said pair should be allowed in order to bring on record all the parties who are required for the proper adjudication of the suit. Hence, I am the considered opinion that the party whom the plaintiff petitioner intends to be impeached as defendant number 11 and 12. There is no defendant number 11 and 12 are necessary parties. The pair for impeachment is allowed. The plaintiff also prayed for amendment of the plaint.
No, intends to bring them as 11 and 12.
Where, my lord? There is no petition filed. In fact, my lord, court on its own can it, my lord, order. There is no defendant in 11, 12, even otherwise. I'll just take you to that. Now, lordship kindly comes to the next page.
Let me see the petition.
Petition. The lordship will find the petition at page 31. The application under Order 6 Rule 17. Even, my lord, government officials were added in violation of 80 CPC, my lord.
Why?
The government, the district collector, the circle officer, there is no statement, my lord, how they are necessary parties. Firstly, the court has to come to a conclusion, my lord. Page 31 is the, my lord, petition. The pleas which I have taken in the written statement, my lord, they are basically to fill up the lacuna after 15 months. Objection is at page.
But he says out there, maybe he may have mentioned Order 6 Rule
That is true,
17.
my lord.
But he said that these people is required to be made parties.
Not sure.
There's no allegation given out there, which means good for him. His lawyer is very clever. Section 80 would not be affected.
No, my lord.
Otherwise, wouldn't 80 come into picture?
Yes, my lord. In fact, there have even lordship under 82, my lord. Their leave has to be taken, my lord.
Not necessary if there is no allegation against them.
No, because, my lord, they have prayed for cancellation of the deed, my lord. That is why-
Cancellation of the deed made by defendant number 6 and 7 in
6 and 7.
favor of defendant number 2 and 3, where the other, those official respondents are much below.
No, my lord, if your lordship says,
Kindly see what they are asked for. Kindly see,
page
what
33.
is the relief sought for?
Relief is,
That
my lord.
the AI executed by the defendant number 6 and 7 in favor by defendant numbers 1 to 5.
Lordship.
Now 1 to 5 is one is somebody else, 2, 3, 4, 5. These are all persons
Lordship.
in favor of 6 and 7. So
The only thing, my lord, the amendment, my lord, lordship will see, the WS was filed on 28/10/2022. The amendment, my lord, was filed on, my lord, 12/3/2024, my lord, after 15 months.
so
Whatever
what?
defense I have taken, my lord.
No,
those
everything is another trial has not commenced.
No, my lord, otherwise even on the date of the.
And the moment the court impledes somebody, the suit comes to the stage of pleadings.
That is true, my lord. But what stage, my lord? Now, lordship, otherwise, there are decisions, my lord, which shows that, my lord, from the date of framing of issues, my lord, the trial starts. So here is a case, my lord, it went beyond. It was at the stage of SBPH, my lord.
SBPH is what stage in the CPC?
Otherwise, it is not, but.
No, no,
there's a-
tell me, let us
No,
also
normally this
understand what
the-
is
this
the
for-
stage of
For
CPC.
furnishing, there is others no provision as such, but below
The word
speaks
used
for-
in steps, the trial will, the framing of the issues will come in. As regards the trial, that's the initial, SBPH is no stage.
Then otherwise, the case was fixed for filing of evidence, my lord. Even otherwise, since since issues have been framed.
But the
then
moment these people are made parties, it goes back
true, my lord, and that is why I am before your lordship.
against.
Because of
These
the
people are
others,
made
my lord,
parties.
whatever defense I had
Who are
taken,
you?
I was the defendant, my lord,
Number one.
lordship.
So what defense you have taken?
My lord, that entire fraud was committed, my lord. There was no agreement as such. Lordship will see two quarters of land for 1 lakh, 95,000 paid. Our full condition that he's a petition writer in Bilasipara. We had given him documents to obtain sale permission in favor of X and Y. Who are parties. That is our, the lordship will kindly come to the written statement.
Amended plain filed.
They have filed.
Why should I interfere now? It was filed on when?
It was
4/1/2025.
lordship.
And you have filed this case when?
It was on 10/5. In fact, there was no court, my lord. So
What?
there was no court
I'm
was
not concerned with that.
that is
code.
otherwise.
You filed
Then
it
what
on 25.
that is true, my lord. That is true.
So that is the fact that we need to dismiss it right away. I can give you one thing that I'll come back and dismiss at 12/5. Come back. Dismiss it now. The supervisory jurisdiction of the court have been invoked to challenge the order dated 2012-2024, passed in Mize case number 40/2024 in connection with title suit number 76/22, whereby learned court of the Civil Judge Junior Division Bilasipara had allowed the said application, thereby in pleading various defendants to the said suit. Defendant numbers 2 to 10 to the said suit. And also permitting the amendment as sought for. The learned counsel appearing on behalf of the petitioner submitted that the said application was filed at the stage of steps before plaintiff hearing, preemptory hearing, bracket SBPH. And as such, the learned trial court, without taking into consideration the aspect of due diligence, could not have permitted such amendment. This court have duly perused the impugned order dated 2012-2024, whereby the learned trial court not only have allowed the amendment but also added defendant numbers 2 to 10. The moment it is the opinion of this court that the moment new parties have been added to the suit, the suit goes back to the stage of pleadings, and as such, the bar which is contained in the proviso to Order 6 Rule 17 would not come into play. Considering the above, this court finds no ground to interfere with the order dated 2012-2024 impugned in the instant proceedings. This court further is of the opinion that the order was passed on 2012-2024 and the amended plaint was filed on 14/1/2025, 4/1/2025 before the learned trial court. The present proceedings was filed on 25/2025 without there being any explanation as to why the the impugned order is being challenged at such a late stage. First, though in the proceedings under Article 227 of the Constitution, the laws of limitation do not apply, but however, delay in filing an application, thereby affecting the progress of the suit, requires that the suit has that the said applicant that there has to be due explanation as to why the impugned order is being challenged after for more than 5 months. Considering the above, this court finds no ground to interfere with the impugned order dated 2012-2024, for which the instant petition stands dismissed. Before parting with the record, this court, however, observes that the petitioner herein would be entitled to file the additional written statement, if so advised.
For admission, item 7.
Wait, reasons.
What is this?
Transfer of a guardianship case, madam, from
Okay.
Nalbari to Dhubri, madam.
Huh?
Nalbari to Dhubri, family code Nalbari to family code Dhubri. Petition preferred by the wife, with whom my lord the minor daughter is currently living. On 2 occasions, my lord, when she appeared there, my lord, she was assaulted once, and on the second occasion, she was even gang raped, my lord. Regarding that, my lord, we have filed 2 FIRs also, my lord.
Where is the child?
Child is with the petitioner, my lord, in Dhubri. Dhubri,
Where is the guardianship case filed?
Nalbari, my lord.
How can it be filed?
It cannot be filed. Where the minor ordinarily resides, and the minor is ordinarily residing in Dhubri, my lord, with her mother.
So did you raise that objection there?
But only on, my lord, 3 occasions we were able to appear there, my lord.
Why?
But 2 occasions, my lord, they have assaulted us, criminal cases are pending. On 1 occasion, we filed a written statement.
Did you raise that objection in
My
a
lord,
written statement?
In the written statement is at page number 46.
Where? Where have you raised that?
Perhaps, my lord, that plea has not been taken.
Huh?
That plea perhaps has not been taken in the written statement.
Where have you stated that the child resides with you? He may also say so, na? Where is he saying?
But for that only, my lord, he has preferred this guardianship case, my lord.
For appointment in a legal guardian of the minor and for grant of permanent custody of the daughter of the party.
We have stated that in para number 13, my lord, in our petition. And my lord, in the petition also, they have categorically admitted, my lord, that the minor is not living with the husband.
heard Mr.
Yes, that's my lord.
As does the learned counsel appearing on behalf of the petitioner. Pusta. The present application is filed under section 24 of the Code of Civil Procedure 1908 for transfer of DC certificate case number 03 of 2021 pending before the Family Court Nolbury to the Family Court Dhubri. On the ground that the minor, on the ground that the Family Court Nolbury has no jurisdiction to decide the question of guardianship of the minor. As in terms with section 9,
Nine.
9 of the Guardianship and Wards Act 1890.
1890.
1890. The learned counsel appearing on behalf of the petitioner submits that in terms with section 9 of the Guardianship and Wards Act 1890, it is the court, it is the court within whose jurisdiction the minor resides would have the jurisdiction to decide a guardianship proceedings. The learned counsel referring to the contents of the petition filed by the respondent under section 7 and 10 of the Guardianship and Wards Act 1890. Submitted that it is an admitted fact that the minor is residing with the petitioner at Dhubri. And as such, it is the family court, it is the district and session judge,
Family court is there.
family court at Dhubri, who shall have the jurisdiction to decide the dispute and not the family court at Nolbury. This court have taken due notice that that pursuant to the filing of the instant proceedings, an order had been passed on 17/7/2023, whereby notice was issued and the further proceedings of GC certificate case number 3/2021 pending before the court of the learned family court, Nolbury, was suspended. And in spite thereupon, service being meted out upon the respondent have not chosen to appear. Considering the provision of section 9, it is therefore the opinion of this court that the court of the learned family court at Nolbury would not have the jurisdiction, as the minor resides within the jurisdiction of the learned family court. Learned principal judge, na?
Yes.
Learned
Principal judge
family
family
court at Dhubri. Accordingly, a bagihini transfer.
Highly obliged, madam.
You have filed your written statement.
Yes, we have filed out.
Good stuff. Both the parties shall appear before the learned family court, Dhubri, on 16th of July 2025. Record to proceeding. So taking into account that the respondent have not appeared in spite of notice, the learned principal judge family court, Dhubri, shall ensure that notice is being issued before further proceeding with the GC case.
Highly obliged.
8,
My pleasure, Lordship. Lordship, there is a statutory appeal filed for enhancement of the compensation, my lord. So basically the compensation was assessed based on the salary of 2005, 6 and 7, whereas notice under section 4 has been issued on published on 2009, my lord. And there one more commissioner's report was also there, who was appointed as a local commissioner, the circle officer. The report says that from 2011 to 22, the land value was 8 lakhs, whereas the land value was assessed as 2,70,000 per kasa.
When was the notice issued under section 4?
My lord, 28/6/2009, but published on 27/2009. Issued on,
2009.
yes.
So how is the circle officer's value has relevance?
My lord, it's just after 1.5 years, but if your lordship have a look,
Did you produce the sale deeds?
no, my lord, could not.
Then?
My lord,
You want a higher amount, so it is your duty to show it.
my lord, the government value is more, from 2011 is much higher
Huh?
than the assessed value, my lord.
Which value?
The government value from 2011 to 22, just after 1.5 years from the date of publication, my
That
lord.
has no relevance.
My lord,
We have to consider as on the date of 9.
yes, my
What
lord.
is what will happen in future is different. You cannot go on the.
And
question of future.
And the collector has also not assessed the value at the time of publishing the section 4 notice, my lord. That was based on the sale deed of 2005, 6 and 7.
5, 6 and 7, so you should have produced any document to the effect. It is your burden.
That is also not relevant, my lord, to 2009, in 2009, my lord.
So if it is not so, what evidence you give?
My lord, the petitioner could not adduce the sale deed, my lord,
Then?
as a comparable,
What is
but the circle officer's report is also considered to be an evidence, my lord.
that the circle officer report is for a period 2011.
11 to,
We are not concerned with 11. There are various judgments of the Supreme Court which says that a subsequent future thing cannot be taken
my lord.
because future many things change. Just for example, your notification is issued on 2009.
Yes,
Thereafter, people come to know, oh, this land is going to be required.
my
So
lord.
therefore, there must be more buying out there.
My lord.
So and accordingly, the rates, this is not I am saying, the Supreme Court in various judgments says so. Why future things should not be taken? No case.
My lord,
You are evidence, you should have said.
yes,
The court would have, the only thing the court could have looked into it as to whether did the defendant adduce evidence or not. The respondents.
no, my lord. They have not adduced any evidence.
When was the award passed?
In the year 2010, my lord.
Then
But the compensation was given in the year 2016. 19/7/2016.
for that you are going to get a possession taken.
Position taken 2010, my lord.
So you will be entitled to interest
Yes, my lord.
under 34.
Yes.
Have they given or
No.
why? Coliseum,
My lord, not 100%.
30% given or not?
I think given.
You are not, you don't know.
My lord, here it's not reflected actually.
It's 70,000.
My lord,
2,70,000
2,70,000 is
the
the
rate.
value, my lord.
Okay. Now kindly come to this. 2,70,000 into 3 will be 8,10,000.
Yes, my lord.
Okay. 8 letters will be how much?
It's half almost 1.5, not 1.5, 1.2 approximately.
8 letters will be, so 2,70,000 is the rate. Where is that pen?
9.5 approximately, my lord. And the value has been given as 13 lakhs.
No, not given. They have only given you this, they have not given the solatium also.
Yes.
Is that your ground of objection? Then appeal filed under section 54.
Yes, ma'am.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. P.T. Appellants, and Mr. P.R. Gogoi, who appears on behalf of the respondent numbers 1 and 2.
Who is highway authority?
The present, it is an appeal filed under. You are not appearing for 2?
I am not appearing to.
Appears on behalf of the respondent number 1. Whose the steps be taken, respond number 1. Whose It is an appeal filed under section 54 of the Land Acquisition Act 1894 against the judgment and order dated 6/12/2024, by which the appeal was dismissed. The learned counsel appearing on behalf of the appellant submitted that the learned court of the district judge Kamrup Metro at Guwahati failed to take into account that it is the duty of the respondent of the collector to adduce evidence as regards the sufficiency of the compensation, which was not done. The learned court, first, the learned reference court has assumed, had presumed that the compensation so awarded, dated, awarded of rupee 2,70,000 was proper and accordingly erred in law. The learned court below, the learned reference court further, as per the learned counsel appearing on behalf of the appellant, did not take into consideration that the appellants were entitled to solatium at the rate of 30% in terms with section 27, 23, 1A. 1A, capital A.
Yes.
Of the Land Acquisition Act 1894. The learned counsel further submitted that the notice that the compensation was also not adjudicated by taking into account section 23 . 23, Solatium is 23.2, 23.2, yes, without taking into consideration section 23.1A in respect to the interest between the dates from the date of payment of the notification under section 4 to the date of passing of the award. The learned counsel further submitted that section 34 of the Act of of the Land Acquisition Act 1894 was also not taken into consideration in the proper perspective. So taking into account the said grounds of objection, the instant appeal is admitted, call for the reports, steps be taken upon the respondent number 2 by way of registered as well as usual. As Mr. Tiago Goy appears on behalf of the respondent number 1, extra copy is furnished upon him.
Much of
Item 9.
It is a statutory appeal under section 28 of the Hindu Marriage Act against a decree of restitution of conjugal rights. The courts did not take into consideration that there are other pending cases, a pending divorce proceeding filed by me, as well as a domestic violence case.
First of all, tell me, do you want to go or not?
No, Lordship. I have filed a divorce petition, that is also pending. I have filed a divorce case as well. That is also pending.
They can't put you behind the lock and key and
They
go.
cannot.
Then this will be a ground of divorce. Desertion. You have filed a divorce case, then you should be happy. You give them another ground. Isn't it?
Lordship. But the direction is against me, so formally.
So if you don't go, you have filed a divorce on the ground of cruelty.
They can pray for attachment of my salary and other things. Also.
How?
For executing the,
How? How is the decree for restitution of conjugal rights enforced? Tell me. Can they pull you?
no, that cannot be done.
What, how, what is the
But
manner?
property may be attached, your lord.
How? This is a judgment, a decree of restitution of conjugal rights is a prelude to a decree for desertion, isn't it?
Yes.
You should be happy. Unnecessary spending time out here. You have to lots of money, I suppose.
Not that, your lordship.
Then, why are you filing this case if you want divorce? What is your ground?
Lordship, the fact of pending domestic violence case was not considered, your lordship.
So?
Because I was thrown out of the house, there was domestic violence. And in spite of that, I was directed to continue the item.
These are evidence, paragraph 5. She admitted that she left the society of her husband on 11/9/2023. At the time, the petitioner was not at home. She has admitted that her husband went to her house after he found that so-and-so. She has admitted that she has locked the phone number of the petitioner because of he keeps calling her. She denied the suggestion that she has leveled false allegation. Okay. List this matter at the stage of Order 41, Rule 11. We dismiss on the next date, either withdraw or dismiss.
I'll take instruction as regards withdrawal.
Find out, I think a restitution of conjugal rights cannot be otherwise enforced. Because you cannot pull somebody and bring her to us. This is a prelude.
Item 10.
Yes, Mr. Bhatta.
Against the quantum of orders.
Ground,
Now is, let's see, the
how much money?
31 lakhs, 1,000.
What is your ground?
Now is that, let's see, there is no proof of income, let's see. This is past the, he was the Bachelor of Engineering, let's see. but he has no service lots.
$20,000 has been done. Then what is there? He was asking for 60,000, has been given 20,000. You should have been happy. Multiplier rightly done. Future prospects rightly done. 40% unemployed.
Interest on
Tono Sethi done. Loss of consortium. Filial 40%, 44,000. And mother is there. There is no sons and daughters.
mother, only mother is the claimant.
Mother is the claimant. Only mother. And it is divided into half.
That's
Oh, okay.
interest on future prospect.
Now, are you going to stop this mother getting all these things? Cost of the proceedings 5,000. Protection of award money 10,000. Good. What is there? No case.
And interest regarding future prospect amount also.
Hello, we modify that. Pay that. Matter over. Where? Future prospects. When did the accident happen?
In the year 17/10/2021.
Then interest at 6% on 8,64,000. How much it would be?
Interest was even 7.5%.
Huh?
7.5%.
7 point, when you are at 7.5, 7.5, that is over. At the end of the day, if I admit the appeal, it becomes 9. Don't you think so? 6-2. Think about it. We'll have it on next date. Dismiss. No stay, no ground.
That's the interest on future prospect amount. That's it.
You're paying 7.5 only. At the end of the day, if I admit it, it becomes 9. And if it is 9, then at the end of the day, when you are paying, you pay more, much more. Huh? Future prospects, I think.
Future prospect amount is what's it? $8,64,000. That part maybe modified. Interest on future prospect amount also. Interest on 8,64,000.
How much? 7.5%.
45,000 into 5 years. Let's see. 1 lakh.
21,000.
No, it's 1,50,000.
What? 1 lakh. 8,64,000 into 3 years. How much? That too simple. Not, it would not multiply.
Let's see, it will be 3,24,000. Let's see.
Huh?
3,24,000.
3,20,000.
8,64,000 into 7.5% into 5 years.
Why you are putting 5 years?
Okay, claim petition was filed in the year 2021.
2021.
22.
22.
22.
So
And this,
we are,
2 years,
we are in 2025. We are making it 5 lakhs.
4 years into year 22, 23, 24, 25. 4 years.
So 22 to 23, 1 year,
1 year.
22 to 23 to 24, 1 year, 24 to 25, 1 year. Matter over 3 years.
And it was 3 years also. 1,94,000.
Huh?
Then it is 1,94,000.
Chala. Okay, we remove the future prospects. Dismiss your appeal. Modify. Heard. Wait. Don't go. Don't explain. I pass the order in your presence soon. Heard Mr. K.K. Bhattu, the learned counsel appearing on behalf of the appellant. Full stop. This is an appeal filed under section 173 of the Motor Vehicles Act 1988. Challenging the judgment and award dated 6/2/2025. Passed in MAC bracket debt case number 1/2022, passed by the Court of the Learned Additional District Judge Dorong, Mongoldoi. For short, that's so and so. Learned Trial Court. Whereby an amount of rupees 31 lakhs have been awarded as the just and fair compensation. And further, it was directed that the said amount shall be along with interest at the rate of 7.5% per annum from the date of filing of the case till the award. And in the circumstance there is delay on the part of the appellant insurance company, in depositing the said amount, awarded amount shall carry interest at the rate of 9% per annum from the date of the award till realization. Full stop. The learned counsel appearing on behalf of the appellant insurance company submitted that there are 2 grounds of objection taken in the instant appeal. First, that there was no, that without there being a proof as regards the income, the learned trial court have adjudged the monthly income at rupees 20,000. And accordingly, the judgment and award so passed is not in terms with section 168 of the Motor Vehicles Act 1988. The second ground of objection so taken is on the question of imposition of interest on future prospects. The learned counsel appearing on behalf of the appellant submitted that there are various laws laid down by the court, various judgments passed by the coordinate benches of the court, holding that there shall not be any interest on future prospects. First, taking into account those 2 grounds of objection, this court finds it relevant to take note of the brief facts which led to the filing of the instant appeal. On 17/10/2021, at about 10:20 p.m., the son of the claimant, while coming from Mongoldoi towards his home by his motorcycle bearing registration number AS01EK 2847. A vehicle bearing registration number AS13 AC0921 coming from the same directions dash the motorcycle wherein the claimant's son was riding from the backside, which resulted in the claimant's son sustaining grievous injuries and succumbing to his injuries. On the basis thereof, a claim proceedings was filed being MAC bracket debt case number 1/2022 before the learned trial court. It is seen that both the learned trial court in the said proceedings, the owner as well as the appellant insurance company filed their written statement. Wherein they denied that there was a rash and negligent driving on the part of the offending vehicle. It is, however, relevant to take note of that in the written statement filed by the owner, he had duly stated that the driver of the offending vehicle had a valid driving license, and the vehicle was also insured with the appellant insurance company, which was valid from 9/3/2021 to midnight of 9/3/2022. Full stop. On the basis of the pleadings, 5 issues were framed, which being relevant are reproduced herein under paragraph 7 of the SEDE, page 12. On behalf of the claimant, two witnesses were examined. Full stop. The appellant insurance company cross-examined these two witnesses, but neither the opposite parties, but the appellant insurance company or even the owner did not adduce any evidence. On the basis of the evidence, the learned trial court, while deciding the issue number 1, came to a finding that the vehicle was issue number 2 came to a finding that on account of the rash and negligent driving of the driver of the offending vehicle bearing registration number AS13AC0921, the accident took place, which resulted in the death of the claimant's son. First, the issue number 3 and 4 related to the quantum. The learned trial court decided the income of the claimant's son on the basis that the claimant's son had just passed the Bachelor of Technology 4 months prior to his death, and there were prospects that he could earn a salary of rupees 50,000 to 60,000. Be that as it may, that's the learned tribunal taking into account the judgment of the Supreme Court in the case of Basanti Devi and others versus Divisional Manager, New India Assurance Company Limited, reported in, reported in so and so. Observed, came to a finding that the income of the deceased would be rupees 20,000. On the basis thereof, applying the law laid well settled. It was the learned first appellate trial court arrived at that the total loss of dependency was rupees 21,600. Further, taking into account the judgment in the case of National Insurance Company versus Pranay Sethi, reported in 2017-18 SCC 130, the learned trial court arrived at the finding that an amount of rupees 8,64,000 would be the claimant would be entitled to an amount of rupees 8,64,000 on the question of future prospects. Further, taking into account the various conventional heads, an amount of rupees 44,000, 16,500, another amount of rupees 16,500 were awarded. Oh. Why only 44,000? It should be, father is there.
Father was not made partnership.
I'm not on that. Other, no. Philel, if there are two sons, he had two sons, then he would have got the parental consortium for two. Does the father has no heart? Is he not going to be sad because of his son died?
Correct.
Eh?
In the evidence, it is not reflected whether the father is alive or not.
Yeah, it is given to the mother and the father on account of loss of estate. By page 22. So we add this 44,000 again. On conventional heads, the learned trial court arrived at a finding that an amount of rupees 44,000, 16,500, another and 16,500 would be awarded towards loss of consortium, loss of estate, and future expenses. And accordingly, arrived at the figure that the total compensation, that the just and fair compensation would be rupees 31,000, 1,000, 31,000, 1,000. It is further seen that the learned trial court further awarded an interest at the rate of 7.5% on the total amount per annum from the date of filing of the case, if the said amount was paid within a period of 3 months. 3 months, huh? How much?
Reflected, that's it.
Huh?
It was not reflected, that's it. Time limit was not given.
7.5% per annum from the date of filing of the case till date of award. And if there is a delay, the simple interest awarded would be computed at 9%. Full stop. At paragraph number 41 of the said judgment, the learned trial court further observe how the amount is also to be paid. Full stop. This court, having perused the impugned judgment, is of the opinion that the findings so arrived at by the learned trial court in respect to the income of the claimant's son appears to be proper, requiring no interference, taking into account that the said decision so arrived at by the learned trial court is based upon the judgment of the Supreme Court in the case of Basanti Devi and another Supra. Full stop. This court, however, finds it relevant to take note of that the learned trial court, while imposing the interest of rupees 7.5% at the rate of 7.5%, did not stipulate within which period the 7.5% interest per annum would be applicable towards the just and fair, towards the award, and when 9% would be awarded. Taking into account that the instant appeal is being taken up within, just within, almost within, well, the instant appeal was filed
Within time.
within the period of limitation, comma, comma. And the instant proceedings, and by this order, this court proposes to dispose of the present proceedings, comma. The interest which would be payable to the appellant insurance company, to the respondent claimant, would be 7.5% if the same is deposited within 6 weeks from the date of the present order, present judgment. This court also takes note of that the learned trial court, while awarding the interest, did not take into consideration that the award so passed included the amount at the included an amount of rupees 8,64,000, which was on future prospects, as well as the decisions passed by this court, wherein it was observed that there shall be no interest on future prospects. Considering the above, this court, although is not inclined to accept the first ground of objection, is not inclined to interfere with the amount so awarded by the learned trial court, comma. However, would like to modify that the interest that the awarded amount shall not include interest on future prospects. First, taking into account the above, this court disposes of the instant appeal with the following observations and directions, comma. The claimant, who is the respondent number 1, herein shall be entitled to an amount of rupees 31 lakhs 1,000, which would be the just and fair compensation as awarded by the learned trial court. First, the claimant would be entitled to interest cost of the proceedings of rupees 5,000. Number 3, the claimant would be entitled to interest on the amount of rupees 23 lakhs 37,000 at the rate of interest at the rate of 7.5% from the date of filing of the claim petition on the amount of rupees 23 lakhs 37,000 plus 5,000. 23 lakhs 42,000. First, there shall be no interest on the future prospects. First, next, this court makes it clear that if the said amount is not deposited, so directed herein above, shall is not deposited within 6 weeks from the date of the instant order, instant judgment. That is, by 7th of July 2025, comma, before the learned tribunal, comma, the claimant would be entitled to a further interest, would be entitled to interest at the rate of 9% from the date of filing of the claim petition. Next. Upon deposit of the said amount, comma, by the appellant insurance company, comma, the learned tribunal shall apply the same in terms with paragraph number 41 of its judgment and order dated 6/2/2025. And release the amount and further remit the remaining amount in favor of the claimant only by way of bank transfer.
Yes, directed to return the statutory revenue.
Next. This court further observes that upon proof of deposit of the awarded amount being placed before awarded amount, proof of deposit of the awarded amount before the learned tribunal, the learned trial court being placed before the registry, comma, the statutory deposit of 25,000 be released.
It is on. On the last occasion, your lordship directed us to file amended appeal memo. Madam. Today I have filed it, madam. Probably it is not on record, madam.
You're there?
For one. Today I have filed it, madam.
What?
The amended appeal memo. Madam. Lordship wanted us to strike off the pro forma respondents, madam, that we have done, and today I have filed it.
Who is in possession of schedule B1?
We are in court.
Where is the finding of fact that you have been dispossessed from B1?
That is there, madam, in the pleadings, madam.
Has filed the written statement to stand that 50 lessons of land in the Putta is located in his name and he is in possession of the family property with the name of the in the case of he is found to be in possession of the land following the sale that he indicated. Where is the finding?
Yeah, page number
That
51, madam.
remains in
Page
the
number
2
51.
acres of land in the name of the family. This is the land from which entity has been dispossessed by the defendant who So the first appellate court ruled as regards the possession of. these scheduled lands.
107, madam. Page number. from para number 16.
Where's the plaint?
Plaint, my lord, starts from 15, my lord. Relevant portion is at 21.
Mr. Hawk, where is the finding of the learned trial court as well as the first appellate court that you have been dispossessed from Schedule B1 land?
It's your lordship, my lords, last occasion observed that after partition, that my lord, these positions can be given. That you,
Understood. That the court have also did. But can it specify B1 schedule if it is a partition?
that was the, my lord, the query of the Senate. So your lordship, after partition, my lord, it can be done.
Then it cannot, therefore it cannot be B1.
It may
So
not.
they will have an entitlement over this.
Two
What is,
kathas of-
what is
two
the
kathas of-
entitlement of the
two kathas of land.
plaintiff over the land?
Two
What is the plaintiff asking for?
2 kathas of land.
A B1.
B1.
So the declaration of right title and interest of 2 kathas is there, but the partition shall be done by the revenue authorities without being without specifying as regard B1.
B1.
That's the only thing.
Only the-
That's the
that
only.
is the-
Heard Mr. S. Das, the learned counsel appearing on behalf of the appellants. And Mr. N. Hawk appears on behalf of the respondent numbers
One and
1, 2, and 3. 1 and 2.
one.
Pusto. This court, by an order dated 26/5/2025, had admitted the instant appeal by formulating a substantial question of law, which reads as under. Pusto. Next. The question which arises in the instant appeal as to whether the substantial question of law which have been formulated by this court under section 100(4) of the code called in the instant appeal. Pusto. This court have duly heard the learned counsel appearing on behalf of the appellant as well as the learned counsel appearing on behalf of the respondent numbers 1 and 2. Pusto. And have also, yeah, pusto. The question of substantial question of law so formulated is only on the aspect as to whether there is a requirement of a modification of the decree passed by the learned trial court which have been upheld by the learned first appellate court. Only to the extent of specifying the entitlement of the plaintiffs in respect to Schedule B1, which is specified with boundaries. First, taking into account that the concurrent findings of facts so arrived at by the learned courts below is that the plaintiff has right, title, and interest over 2 kathas of land. Which is a part of the Schedule B land And the plaintiffs are also not in possession of the Schedule B1 land, comma. It is the opinion of this court that there is a requirement of modification of the decree so passed by the learned first trial court. Dated 25/11/2019, passed in title suit number 81/2016, which have been affirmed by the judgment and decree dated 5/10/2024, entitled Appeal number 5/2021. First, the modification which is required is that the plaintiff has right title and interest over 2 kotas of land which is included in Schedule B to the plaint. First, accordingly, the instant by this accordingly, this court therefore is of the opinion that the substantial question of law is duly involved in the instant appeal. And accordingly, the impugned judgment and decree so passed by the learned trial court dated 25/11/2019, entitled suit number 81/2016, and affirmed by the learned first appellate court by the judgment and decree dated 5/10/2024, passed in title Appeal number 5/2021, stands modified as hereinafter with the following as hereinumber. First, read the decree.
Decree, my lord, 52.
Next. Number 1. The plaintiffs have right title and interest over 2 kathas of land, which is a part of the Schedule B land. Number 2. The plaintiffs are entitled to partition the said 2 kathas of land, which is a part of the Schedule B land, by creation of a separate dag and patta number in their name. Accordingly, this court issues precept to the concerned, to the commissioner, to the deputy commissioner, which district? Borpeta. To partition the Schedule B land and thereby creating a separate dag and patta number in the name of the plaintiffs of an area at measuring 2 kathas. Next. This court, upon ascertaining, upon making the partition, the deputy commissioner, Borpeta, or any officer so authorized to carry out the partition shall submit a report in terms with section 54 of the Code of Civil Procedure 1908 to the learned trial court, that is the court of the learned Munsif number 1, Borpeta. On the basis of the said report, the learned trial court, that is the learned court of the Munsif number 1, Borpeta, shall pass the final decree. Why is it required for a preliminary decree?
Was that Where was for partition, man, that is why.
So what? If it is done under 54, then why is a preliminary decree required? It's okay. Take it out. We'll pass a final decree. First. Number 4. Final decree. As regards separate possession, pass a final decree as regards separate possession and recovery thereof in favor of the plaintiff. Next. The learned trial court shall further pass any further relief or reliefs as deemed fit as have been prayed in the suit. With the above, the appeal stands disposed. I thought all of that was done. The registry shall forthwith prepare a decree and forward and place and forward it to the learned to the deputy commissioner, Borpeta. The deputy commissioner, Borpeta, shall ensure to carry out the partition either by himself or through an officer duly authorized within a period of 6 months from the date of receipt of the said decree.
Daily list item 11.
Enhancement, why?
My lord, the,
You have got how much?
my lord, 14,50,200.
How much do you want?
My lord, what happened, the income of the deceased? The claimant has claimed that rupees, my lord, 16,258. But, and to prove that, my lord, the salary certificate was exhibited as well as the employer was examined. But since employer in his cross-examination said one statement that he used to employ the persons for 11 months only. That's why the tribunal has not accepted the salary certificate and instead of 16,258, my lord, awarded rupees 9,000 per month.
This is an appeal filed by so and so, so and so, so and so. The ground of objection so taken, look. The ground of objection so taken in the instant appeal is on the question of inadequacy of the compensation. On the ground that the learned tribunal had failed to take into account the salary certificate while computing, while arriving at the just and fair compensation. The learned counsel appearing on behalf of the appellant submitted that the compensation so awarded was not in accordance with section 168 of the Motor Vehicles Act. Accordingly, appeal admitted, call for record steps be taken by way of registered as well.
Okay.
Then appeal filed under section 163 of the Motor Vehicles Act.
12.
My lord, insurance company is in appeal here.
Huh?
Insurance company is in appeal here.
Why?
My lord, first of all, the driver, the deceased, was driving a oil tanker. But there is no separate endorsement that he was fit to drive a hazardous, the vehicle having hazardous substance, as per rule 9 of the Central Motor Vehicles Rule.
Then?
So this is the first ground of attack. Ground, my lord. Secondly, he was taken to be a skilled worker with certificate. So it ought to have been.
No, deceased is what?
Deceased was driving at oil tanker. He was hit by a dumper. Now we say that the deceased was not holding a valid driving license at the time of driving the vehicle.
But what did the court find?
Court did not go into that aspect.
No, I'm asking you, what did the court find as regards the rational negligent driving is whose?
It says about the dumper. About the dump.
Then, whoever is driving what, how does it matter? I would have understood this, did you raise the question of, give evidence as regards contributory negligence?
Contributing, we have raised. We have raised.
Then what happened?
It was negated.
Evidence.
Evidence,
Evidence.
DW we have stated, it was,
What did he say?
it says, when,
It's a case of contributory negligence.
we have stated, we have adduced evidence.
So what is the contributory negligence? That he drove wrongly.
No, it was a head-on.
He may not have an insurance. Just for example, a kid today is sitting out there in a vehicle. Then, and he's putting, somebody comes and bashes the car. Then,
So we have laid evidence that there was contributory negligence.
then
Because it was a head-on collision, it was on broad daylight on the middle of a road, it occurred. So it should have been a 50-50. So that was negated by the largest.
let us see where.
Page 17, my lord, paragraph 24. Paragraph 24. It was revealed the accident occurred due to head-on collision between the vehicles so and so and so and so.
That he has been posted in.
He has also referred to police reports.
So, no sketch map. It was not in the middle of the road. Court has duly considered. What evidence did you give?
That is the evidence.
No evidence. So
And
first
secondly,
point goes. Next.
secondly, my lord, the age of the victim was taken to be in between 36 to 40. And accordingly, as per chart, multiplier should be 15 instead of 16. That is,
This is taken on the basis of the driving license. At
think-
35 years, 2 months.
yes, 35 years, 2 months. So in paragraph 47, if your lordship see, he was placed in the age group of, it should have been 36 to 40.
So he should have given, he should be paid more money.
No, it is wrongly written as 46 to 50. It should, let us take, it is 36 to 40. Then it should be 15 instead of 60.
Why?
Well, as per the chart of this Karlavama,
46 to 50.
no, it should be 36 to 40.
Then what should it be?
It should be 15.
Huh?
1-5.
Show me that. For 36 to 50 only, he was only 35 years. So it was 16, rightly done. It is given paragraph 46. M16 for 31 to 35 years.
Yes, 36 to,
He's not
40.
36 years, he was 35 years, 2 months.
so 30, it should be 36 to 40.
Supreme Court says 36. This is not 36. He's 35 years, 2 months.
If your lordship would see 47, page 47.
Ah.
This is clearly he intended to see, write 36 to 40. It cannot be 46 to 50. If your lordship would see paragraph 47.
Ah.
He wrongly typed it as 46 to 50.
That
It
forget
cannot-
about
It should
forget
be
about that.
36 to 40.
Mr. Vatsalji, question rises out there. This person was 35 years, 2 months, 4 days. That is at paragraph number 44.
Yes.
So therefore, the multiplier will be 35. For 35, it is 16. Right? Then next,
And next is, my lord, future prospect, or the interest on future prospect.
okay, we modify that. Over.
Lordship may examine the case after
Okay,
getting the
deposit the
LCR.
entire amount. No case. When did the accident happen?
20, it is on 9/7/22.
Huh?
9/7/22.
20. Why they have put 40,000? Consortium, it should have been more. Don't you think so?
Per year.
3 years is over.
3 years.
Is over from 2017.
Yes. Yes.
So this consortium has to go up.
Yes. Yes.
So in all these cases, there are parental consortium, spousal consortium has to go up. So this is 32 lakhs, na?
Yes.
You deposit 34 lakhs before the tribunal. Along with interest from the date of interest is given when? 9%.
9%.
No, where?
Page 63. Paragraph 63.
Where?
9% per annum from the date of filing of the case.
Where is the 9% interest has been given? Ah, yeah. Is directed to release the awarded amount along with interest at the rate of 9% per annum, so and so till the payment till favor of a year. Chalo. Wow, how much interest should be?
I say it should be 6%.
So you deposit 6% along with this, and we add it, make it 34 lakhs plus interest at the rate of 6%. Deposit it. We admit the appeal. 3% will consider after hearing the other side.
Well,
Otherwise, there is no case.
regarding these two things. My lord, this one, the multiplier.
Multiply is okay. It is a case for dismissal.
Because writing it.
Only 3% interest we are the concern. We'll take care of it later on. देखो. With an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and order dated, award dated 28/2/2025, passed in MAC case number 1217/2022 by the learned member, Motor Accidents Claims Tribunal number 2, Kamrup Metro at Guwahati, or short, the tribunal, comma. The learned counsel appearing on behalf of the appellant have raised 4 grounds of objection. The first ground of the objection is that the driver in the case of the driver, the deceased, who was the driver of the old tanker, did not have the license, did not have the certificate for driving the hazardous vehicles.
In terms of Rule 9.
In terms of Rule
9 of the Central Motor Vehicles.
Central Motor Vehicle Rules. Pusto. The said objection in the opinion of this court is required to be required to be rejected on the ground that the appeal on the ground that the learned first tribunal had duly considered that it is on account of the offending vehicle, that is the dumper, bearing registration number
AS07
AS07 BC 1159. The accident had come to a categorical finding on the basis of the evidence on record that it was on account of the rash and negligent driving of the offending vehicle, that is the dumper, bearing registration number AS07BC1159. And as such, the said ground of objection cannot be taken into consideration. First. The second ground of taking cannot be, has no merit. The second ground of objection so taken is the multiplier which have been applied should have been 15 and not 16. So this court have duly taken note of the findings arrived at by the learned trial court tribunal to the effect on the basis of the driver license, that is Exhibit 5, that the age of the victim was 35 years, 2 months, 4 days on the date of the accident. First of applying Sarla Verma, the judgment of the Supreme Court in the case of Delhi, what is that? Sarla Verma, what is that name, full name? In the case of Sarla Verma and others versus Delhi Transport Corporation, reported in 2009, 6 SCC 121. In the opinion of this court, that the learned tribunal had rightly applied the multiplier number 6, multiplier 16, taking into account that the Supreme Court had categorically observed that for the age from 31 to 35 years, the multiplier for 16 would be applicable. Under such circumstances, this ground of objection does not hold water. Number 3, the third ground of objection so taken is
Contributing negligence.
contributory negligence. On the contributory negligence on the part of the vehicle, on the part of the oil tanker. This court have duly taken note of that there was no sketch, there was no evidence that though the appellant insurance company had adduced evidence in respect to evidence, but the person who had adduced the evidence was not present, was neither an eyewitness nor he had produced any documents to show that the accident occurred in the middle of the road. There was no sketch map also produced. Considering the above, as the burden lies upon the appellant insurance company to have adduced evidence if the defense of contributory negligence was taken, and having failed, this ground of objection does not also hold water. Number 4, the learned counsel further submitted that the next ground of objection is on the question of
My lord, the deceased was taken to be a skilled worker with certificate. It ought to have been skilled worker without certificate. Then the minimum wages would have been a little less.
how
They
much
have-
it has been taken.
It was taken as 14,989.
This is too less. Don't make that submission. Then next,
And the interest on future. costs.
submitted that there is an interest that the learned tribunal had imposed an interest at the rate of 9%, which is a higher on the side, and that too without taking into consideration that the interest was also awarded on future prospects. You are going to on 71. 71,000 you are saying about interest. How much interest would it be? If I admit this appeal, this matter goes for a 6.
If in the meantime,
71,000 is the future prospect. Earlier case, future prospect, I reduced it because it was 8,64,000. This is 71,000 only. This is too less.
then the interest of 3%.
Huh?
Interest of 3%.
This is given as per Supreme Court judgment.
There are other judgments also.
on the interest on future prospects. Full stop. Full stop. As well as the interest being higher. Full stop. Only on these two grounds, that is interest on future prospects as well as the interest being higher, this court admits the instant appeal. Call for record steps be taken upon the respondent so and so. Stay on a divo. This is an application for stay of the judgment and decree dated so and so passed in a year. The appeal, this court have duly considered the impugned judgment and decree, and only on the point of interest on future prospects as well as on higher interest on the higher rate of interest, the accompanying appeal has been admitted. Considering the above, this court therefore directs the petitioner, the applicant, and that this court therefore stays the impugned judgment and decree dated 28/2/2025, passed by the court of the learned so and so in MSC case number so and so, subject to deposit of rupees 32,51,824.64, along with interest at the rate of 6% per annum from the date of filing of the case claim proceedings, that is 11/8/2022, within 6 weeks from the date of the instant order. First, the learned before the learned tribunal, within 6 weeks from the date of the instant order. This court further directs that upon deposit of the said amount, the learned tribunal shall apply the same in terms with paragraph 64, 65, 66, and 67. 64, 65, 66, 67, and 68 of the judgment and award impugned in the instant proceedings. Full stop. The interest mentioned in the said paragraphs 64, 65, 66, 67, and 68 till the disposal of the appeal shall be read as 6% instead of 9%. The amount be released subject to the observations in favor of the claimant only by way of bank transfer.
13,
Yes, you got your file.
My lord.
Fantastic.
At page my lord, 23.
What are you challenging?
My lord, I'm a skilled labor, my lord. I have submitted, my lord, the certificate, my lord. At page 23, para 31, my lord.
Then
I have, my lord, my income was, my lord, 20,000 per month, my lord.
but you only said that
I have
not produce any admissible evidence.
Exhibit 7, my lord, I have submitted.
Then
At para 3, page 5, my lord. This is my ground, my lord. Only ground, my lord.
okay, the instant appeal is being challenged. The present appeal has been filed. Have been filed on the sole ground of objection that the monthly income of the deceased was not properly appreciated, not properly arrived at by taking into account Exhibit 7, which was issued by the President Beton GP. And the learned tribunal had relied upon the minimum wages notification of the Labor Welfare Department of the Government of Assam. The learned counsel appearing on behalf of the appellant had submitted that had the amount mentioned in Exhibit 7 would have been taken into consideration, the award of compensation would have been much higher, taking into account the appeal is admitted, call for record steps be taken by way of registered as well.
All right.
Got your file?
My lord.
Item 14, hearing under order 41, Rule 11 CPC.
Yes,
Memo will be not received.
you
by
should
the
not
respondent.
receive.
Lordship, he wants the appeal to be admitted so that I can deliver a copy to him.
My appearance has already been completed during the course of hearing of the IA petition.
Are you on caveat?
Pardon?
Are you on caveat?
No, no,
Then take your seat.
not okay.
Apparently, I have no case. But, Lordship, but
Yes. Tell me.
Exhibit B, which was produced by the, it is shown that I have not filed any exhibits. Exhibit 1 to 3, that is not, that is missing from the, missing in the sense, though it is evidence, it is shown that exhibit 1 to 3.
Ah.
But it was that learned trial court opined that there was no such exhibit, as such, we have no case. On the other hand, the exhibited document filed by the defendants, exhibit A, B, C.
Plaintiff, no exhibits.
Lordship,
Defendant, exhibit A to
B-
F.
A, B, C. On,
Was the suit decreed?
no, dismissed.
Then
Thereafter, it was,
Suit-
appeal was, that was also dismissed.
suit, you are the plaintiff?
Yes, Lordship.
What is your suit for?
Suit for declaration and confirmation of position.
Huh?
Declaration and confirmation of position.
Declaration of right title.
Right title.
On what basis? Oral evidence?
No, Lordship,
Then?
I had the document, that document, I do not know how it was not produced. But exhibit B, filed by the defendants, my name is Sondhya. In exhibit B.
Certified copy of the Jamabuddhi.
Lordship, exhibit
Then?
B,
Then
one thing. Secondly, the document that which they claimed it, they had land, but in under that. So they did not have sellable right. The vendors of the defendants did not have sellable right at the time of,
he's
This one.
not on counterclaim.
he was not in counterclaim. Therefore, my submission before this honorable court, the people may be admitted on the ground of this document, I may be allowed to file those documents if possible.
My goodness, that is too much.
Lordship, even then otherwise that exhibit B, the exhibit B will do.
No, you don't want to spend the money on making photocopy of the appeal and giving it to him.
I'll like,
I appreciate that. You should not. But you don't have your case then.
Lordship, I have,
How did you prove?
I have a case. Because
You
that
don't have a case.
I
You
have a
did not
case.
adduce any evidence to the effect.
but exhibited document by the document defendants itself shows that our name is there.
Show me mainly on the basis of the Jamabandi.
Yes, Lordship.
So are we therefore to say that because of the defendant's case, you have a case?
Exactly, it's so, but defendants, at least defendant number 1 and 2 did not have the right. They claimed the land on the basis of a sell deed. Sell deed, which they got it from defendant number 3. So defendant number 3 did not have a sellable right in the particular bag. He had sellable right in 4 kotha and other
We have
bag.
not challenged a sale deed.
Because I don't need to sell, because that is the sell deed is executed in my
Yes,
that,
therefore you have to prove your title.
even otherwise also.
Either you challenge the sale deed or you have to prove your title. If you have to prove your title, you have to base on your case.
Lordship, even otherwise also that had the both the trial court as well as Landed Appellate Court peruse the document B, exhibit B.
Exhibit B is the mutation.
No, Lordship. I do.
Yes, it is the record of rights. The mutation.
I had a.
These are
I-
revenue records.
I had sellable, I had a right over 3 kotha 18 lasa.
How does the court declare?
Court did not say, the court said.
How will the court declare?
Court did not consider that particular.
You have given the evidence of 1, 2, 3, 4,
Yes, Lordship.
but no document.
That is only the, because in that case, the court, at the time of pronouncement of judgment, the court should have given us an opportunity that these are the documents are not there. Because at the time of filing, we produce the documents. If it is exactly, it must have happened at the time of taking evidence before the commissioner. This problem must have occurred. So therefore, at the time of pronouncement of judgment, the learned trial court should have.
You
asked-
may give only some soul of happiness to him by giving him a photocopy.
Oh, Lordship, I'll give him the
Only.
copy.
But otherwise, without a photocopy, he has to appear. But I'm going to dismiss your appeal. There's no question.
Lordship, it
He
will
may
be-
only
it
have
will
a
be true.
happiness.
It
If
will
you
be
want
true.
to save yourself from the spending that money for
No,
photocopy,
Lordship, I'll give him.
then I
right now.
dismiss it right away.
Lordship, I'll give
Which
him
one
right.
do you want?
Lordship, I'll give you right now. Only thing, my problem is that now I have a
I
right.
will not recognize that you are going because of the fact that he is not on caveat.
Lordship,
And without this court admitting the appeal, I am not going to hear him also.
Lordship.
Only his happiness is that
Yes. he
his
should
name
get a
will
copy.
be
He
recorded.
should be copied.
Huh?
He should get a copy and his name should be heard.
Otherwise, no case. I'm going to dismiss your appeal.
Lordship, in that case, it will be too hard because I had a sellable right. I had a right over 3 kotha 18
How
lakhs.
do I help you?
Because it is the conduct.
I am on the. Did you file an application and order for 41 rule 27?
No, Lordship, even in
Then-
appeal, that was not.
Then how
Even
do I
otherwise
help you?
also for the fault of a advocate, that should not have been. It is exactly.
I
case of-
understand one fault in the trial court. What about in the appellate court?
We were not there because somebody else was conducting that.
The problem arises that Mr. Bhagavati cannot be omnipresent.
Yes, Lordship, that is, yeah, that is there. That is my humble submission before this honorable
That
court.
cannot be a ground.
That on the.
When
exhibit
do you
B,
want the dismissal? Pick a good date.
Lordship, exhibit B speaks.
No. Sorry. This type of submission doesn't work good with.
I'll give him copy. Let us again come back. Let us again come back.
Again come back. When do you want?
Next week.
When
Next
do you
week.
want?
Next week.
Chalo. You want the 61 number. Okay. Good. We'll have the opposite number 16.
Lordship.
At least the
Lordship.
matter on 16th. Lord, yeah, 16th of June 2020.
15,
Wait, please, hold on.
Ah,
With the regular second appeal, madam, the question here involves, madam, that whether long possession of one course error will extinguish the title of the other course errors over ancestral property, madam. That is the moot question. One course error will extinguish the title of the other course errors over the ancestral land,
over long possession.
long possession. On that
So-
basis only our case was dismissed, madam.
Court said it to be a adverse possession.
No, no such finding was given, but just because we could not prove our possession, we could not prove our dispossession from the suit land, the court on the basis of mutation entries, which were from the 94, on the basis of mutation entries, minor, the court said that since you could not prove dispossession, so you have no case, and the entire suit was dismissed. Whereas we were pattadars and the defendants are also pattadars, and the land was ancestral land. They are the sons and daughters of the first
Let
land.
us see that finding.
Yes. Page number, my lord, 60,
Appellate court.
appellate court 99. Court relied on Amiawala judgment, ma'am.
Huh?
Amiawala judgment, the appellate court relied and said on the basis of mutation
Land
entries.
is in partition between the brothers and sisters who enjoy no objection. No case was also. Where is the finding that the plaintiff is otherwise the owner?
We have,
Without that owner, your question of law does not come.
we have exhibited all the documents.
What documents? What are your documents?
At page number, my lord, 66, 65.
Certified copy of the Jamabandi, certified copy of the Chitha, revenue receipt trace map of the Sardar Jamabandi. Certified copy of a viable Chitha. So your claim of title is on the basis of
And
what?
just on the basis that, my lord, we are the legal heirs of one, Kurpan element.
No,
He
what
was
is
the
your,
original
what
partner.
is your claim of title?
Legal heirs, man. of
Your
Kurpan Ali.
brothers?
Yes. Kurpan Ali is the original partners, but we are the sons, daughter, and wife of Kurpan Ali. And the defendants are the sons and daughters of the first wife of Kurpan Ali. That's why we have also sought for partition, madam. That was also not granted.
You asked for partition?
Yes. At page number 30,
Which is your substantial question of law?
substantial question of law, madam, page number 15.
You have executed deed of relinquishment.
That was their case. They could not execute. That is their case, defendant's case. That
They did not adduce that.
No. Page number 66, these are the exhibits of the defendants.
Do they admit in the written statement that they were joint ancestors?
Yes, yes, that is their case. Page number 42. 42, B,
We are concerned with Schedule C land only.
yes. Schedule C line is the share of the plaintiffs,
Huh?
share of the plaintiffs.
How do you say so?
Because, madam,
What are you asking for?
we are basically
The
asking,
Schedule D land is a part of the Schedule
Yes,
1 and
that
is
they
a
have
part of
disposed.
so and so. Decree for declaration, the plaintiff and the defendant have common right, title and interest upon the Schedule C land within a Schedule land.
C is the, madam, land of Kurpan Ali. That is their predecessor.
What is your prayer?
Prayers are multiple, madam, at page number 30.
Well, let's read this matter again. Let me go through the judgment one. This matter, Mr. Heldas, learned counsel appearing on the of June 2025.
16,
Where do?
The formulated
Deed of settlement was not registered.
Yes. No, it was not registered.
Then
It was if your lordship sees the family settlement, it is annexed to your
no,
lordship.
the family settlement is not required to be
No,
registered.
that is not required. So
Then
the concept was that the finding is that because it was not registered, no legal cognizance can be taken. That is the finding of the,
put the courts.
no, trial court was in my favor. It is a case of reversal.
Whether there was any creation of rights.
No rights. It was, I'll just means give it. It was decided that because they were at that point of time in 1982, all the family members were staying in a rented premises. So they decided that they are going to contribute, all the earning members would contribute a fund. The father and the mother and the earning brothers would contribute a fund and purchase. They had already discussed with a particular person to purchase a plot of land, that they are going to use that for purchase. So that was there, and it was decided that all of us, the recital was that all of them would reside over that, and they are not going to sell it to any other person. That was the general concept of that. So there was not even the land purchased at that point of time. There was no
So
extinguishing.
you were the
nothing.
plaintiff or the defendant?
Pardon me.
Were you the plaintiff or the defendant?
I am the plaintiff. We sought for because one of the brothers,
What did you seek for?
uh,
Where is your plaint?
yes, we sought for partition.
Huh? Decree for declaration that the scheduled property is the joint family property of the plaintiff, and decree for declaring that the family was binding upon both the plaintiff and the defendant. Decree for declaration and interest of remand as being the co-owners of remand. Decree for declaration that the defendant plaintiff and are entitled to remand. Decree for filing decree of partition by meets and bounds for mandatory injunction. So what did the trial court do?
The trial court came to the finding that
There was
it
a counterclaim also.
Pardon your lordship.
There was a counterclaim also.
There was a
Then what happened to the counterclaim?
counterclaim was dismissed at that point of time, but now I have filed a second, another appeal is pending. It has not been listed, where the appellate court has upheld his counterclaim and has rejected my claim.
That has not been registered.
We had filed it along with it, but somehow it has not been listed, your lordship. There is some objection.
So if we dismiss this, that will get dismissed?
Your lordship.
No, I'm asking you.
I feel that there is a case, your lordship, before your lordship.
So the moment I admit here, let us see the findings of the learned trial court. Trial court's finding is what?
The trial court's finding, your lordship will find at page 132.
And what is the defendant's case?
The defendant's case that he is the owner because the total land was purchased in his name. And so, though he admits that was staying separately, so his case is that he is the entire sole entitlement is there on basis on the sale deed.
On the basis of his title,
Yes.
title deed. So you want to say that that was a benami?
Benami in the, it is a benami, but the family agreement clearly shows that it was an offshoot of that, because if your lordship sees the family agreement, settlement,
What is the 1971 deed of sale?
the 1971 deed of sale is the 71.
Exhibit B.
82.
Exhibit B.
The sale deed was in the name of the defendant, which we purchased after the contribution, because at that point of time, we needed, because the land was vacant, it is in the recital, that as the land is vacant, there were two brothers at that point of time, the appellant number 1 and the
No,
defendant.
no. The land was purchased by Exhibit B.
Yes, I think. It was by exhibit B. Yes.
Why there are two deeds of sale?
Exhibit B of the defendant. Registered sale deed.
Hmm?
Yes, for taking the housing loan.
No, exhibit B is by what? By whom?
It is by the defendant.
Where is the plaint?
The
And why have you enclosed this evidence?
evidence because there was some
Huh?
admission in the DW statement.
So,
Just the plaint is, your lordship,
where is the plaint?
plaint your lordship will find at page 43, your lordship.
Got it. You added, yeah.
And the WS come counterclaim is at page 77. And the defendant's stand was that it was a forgery, etc., but he did not produce any document or something to substantiate that. And that is the specific finding by the learned trial procedure.
Oh, this sale deed was executed in the year 1983.
Yes, sir, just after the,
Oh, yeah. Then what happened that you had to file a suit for partition?
because we were staying together, then he started disconnecting the electricity and trying to dispose the other plaintiffs from over the suit line. And because of which we had to come forward and file this, your lordship. And this particular statement, I think, is there in the plaint.
So they tried to vacate you.
Yes, sir. Means all the other brothers are staying together. He was staying with his wife in his wife's quarter in railways in Maligaon.
And let's see the finding of the learned trial court, first appellate court in respect to the family partition thing.
Yes, your lordship. Your lordship will come to the family partition, your lordship. Your lordship may come to, it starts from para page 30, while deciding issue number 3 and 4. Now, the relevant portion which I wish to draw your lordship's attention is at page 34 at para 26. The last 4 lines of the para 26. Here the finding starts, your lordship. If I may read out it. Para 26, page 34. The issue was framed on the basis of whether the family settlement is a forged one. And the finding is with regard to section 17 and non-mentive, the thing having no legal sanctity. Your lordship may come to page 34, your lordship. Para 26.
Who took the loan?
The younger brother, the defendant out here.
He took the loan to purchase it. And what right didn't you have?
No, because it is in the recital that because one of the, if your lordship, that is why I wanted, the recital clearly says what, that he will take the loan, everything is on the basis of all the brothers acted upon this family settlement, your lord. If your lordship sees the family settlement at page 94,
Only one question.
the first interpretation,
No interpretation. Interpretation wise, right?
because he comes to a finding that how can the father relinquish shares, that is not
It's
done.
a finding of fact. We are only on the question of the, what do you call that? Section 17.
The stay application is there.
Mr. A. Viswas, the learning counsel, appearing on behalf of the petitioner, who's with an appeal under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 14/2/2025, passed in by the Court of the Learned Civil Judge, Senior Division Number 3, Kamrup Metro at Guwahati, entitled Appeal Number 12/2023, whereby the appeal was allowed, thereby dismissing the suit filed by the appellants. First, the instant appeal is admitted on the following substantial question of law. First, whether the learned court below, learned first appellate court, was justified in rejecting Exhibit 1, that is the deed of family settlement dated 1/12/1982, on the ground that the said deed of family settlement was not registered under Section 17 of the Registration Act 1908. First, call for the record, steps be taken upon the respondents by way of registered as well as usual. How many respondents we have made?
Single,
Only one.
yes, because all the others are the brothers who are staying there.
Only that issue,
Only that.
short issue which dispose it of before vacation.
Yes, sir, that's what I said. A stay application is there.
Is an application filed under section order 41 rule 5 of the Code of Civil Procedure 1908 for stay of the judgment and decree dated so and so. Issue notice making it returnable on 25th of June 2025. Steps be taken by way of registered as well as usual. In addition to that, the petitioner is also the applicants are also directed to the fixed service upon the respondent by way of the stay routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. Taking into account that the decree which has been passed in the instant appeal in entitled appeal number 12/2023 is an executable decree, and the fact that the accompanying appeal has already been admitted, this court is of the opinion that till the next date, the judgment and decree, the impugned judgment and decree dated so and so 14/2/2025, passed entitled appeal number 12/2023 is required to be stayed. Accordingly, title appeal number, judgment and decree dated so and so, entitled appeal number shall remain stayed till the next.
Obliged, sir.
Supplementary item 43.
Note sheet may kindly be sent. Note sheet is there, man. Well, there is. On last occasion, on 9/5/2025, appellant was directed to pay the court fee for the counterclaim, my lord. My lord, we have filed the counterclaim court fee today only, my lord. But it has been not in the
It has been submitted by the learned counsel appearing on behalf of the appellant that the requisite stamp duty have been paid, court fees have been paid. The registry shall update the same in the memo repeat and place it. On, when do you want?
Monday, 9th.
Huh?
9th of June, man.
9.
Stay matter item 40.
As per office note dated 35/2025, the service is processor, the service is available for full response.
Why you are not in a position to serve it?
Because I'm staying in the Manipur, so I'm the old lady, I'm the lady, I'm staying in the in Moriani, and she and my husband, he decided to Dimapur.
Oh.
So
Sorry.
he's some local. So I'm in the ladies, so I'm not a position to go.
You
in
have given
because-
insufficient address. We should vacate that order.
No, because your lordship may see the address which they have given. in
You
the
don't know
divorce
where
case
your
number.
husband resides.
What's it?
You don't know where your husband resides.
He's there, lordship. He is a resident of the powerhouse colony, Burma camp. It
Then?
is an address in page 34, annex 3, which I mentioned. It is
Then?
divorce certificate. So this is the address. And also in notice, in affidavit, page 42, same address is there.
Powerhouse Colony, Burma Camp, District Dimapur. If you cannot effect service upon this person, then obviously we cannot stay it, no?
Because address is
We have to
there, so-
vacate the stay order.
Because we are unable to go there because he is their residence are there, so we have some.
So effect service by way of Dusty. You know where he resides.
He's in the powers at the Burma colony.
So go
Okay,
serve it.
then lordship. may
Learned
let me
counsel
Dusty service.
appearing on behalf of the petitioner submits that he may be, the petitioner may be duly permitted to take steps by way of Dusty upon the sole respondent. To stop taking into account the above this matter on 27th of June 2025. In the meantime, the petitioner is directed to effect service by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. Interim order passed earlier shall continue till the next date.
Can it be?
41.
Maybe. In this case, my lordship may kindly peruse the order dated 30/5/2025. We have taken steps, my lord, and the Dusty service, we have been filed affidavit.
What you have challenged here?
We challenge the when we file an application before the before the Islamic trial court for impeding as party respondent, but that was rejected. On the ground that the mandir is within the boundary of the land, and it is an admitted fact. The plaintiff as well as there are several reports in our favor that the mandir is there.
Your service is done.
Yes, we have filed the fee regarding affidavit that they refused to accept.
You taken steps by way of Dusty.
Yes, also the fee, then restart post as well as legal process.
Huh?
Yes, madam.
Dusty, you have not filed.
Today we filed the affidavit.
Where is that? It has been submitted by the learned counsel appearing on behalf of the. Who has received this?
It was refused to receive.
Huh?
You notice they did not receive.
It has been submitted by Mr. D. A. Kaim, the learned counsel appearing on behalf of the petitioner. That upon upon effecting service upon the respondents number 125-126-5-2025. All the respondents refused to receive copy of the dusty. And in that regard, an affidavit of service have been duly filed. So, taking into account the above, this court that the deems that the service upon the respondent is complete. The registry shall bring on record the affidavit of service. Further to that, taking into account the above, this court for the ends of justice fixes this matter again on 16th of July 2025. The interim order passed earlier on 28/4/2025 shall continue till the next date.
For orders, item 17.
Lordship, on last occasion, we made a mistake, Lordship. We prayed for striking out the name of appellant number 1, 2, and 3. But in fact, appellant number 3 was already substituted. So that order may kindly be modified, and Lordship, we may be allowed to file amended cost title. And appellant number 1, 2, 3, Lordship, we prayed for striking out the name of appellant number 1, 2, 3. But in fact, appellant number 3 was already substituted in the year 2014. So, Lordship, accordingly, we have filed the amended cost title with appellant number only 1 and 2. The others we removed from the array of appellants.
Now the service complete.
Service there complete, Lordship.
I have also made a mistake on the last, I have also made a mistake. An application we have filed under order 22 rule 10A, informing that the legal heirs to be substituted for this is respondent number 1 and 2. Now, while filing this application, the wife of respondent number 2 left out because later on they are saying the wife aged about 65 years, she is alive. So I may be allowed to file an impediment application, including the wife of deceased.
Who are these people? They were defendants.
Yes. Respondent number
It's a suit for?
right title and confirmation of possession.
Otherwise, service is complete.
Lordship.
Okay, listed for hearing.
And
Taking into account that the service is duly complete and the records have been received, list the matter for hearing in its usual course, liberty given to both the parties to file application for early hearing.
Lordship, in the meantime, if your Lordship permit, I will withdraw my amended cost title and again I will file the amended cost title.
Lordship, I may be
No
allowed.
permission, nothing to that effect
I
without
may-
it. That is your lookout. Why should I allow you?
Obliged.
18,
Yes, why this service is not complete?
I have taken step upon the response number 2, let's see. I have taken step, let's see.
Huh?
Step I have taken, let's see.
No, Dusty.
Dosti regarding Dosti, earlier it was affected, today I have informed that it was affected. I have to file a affidavit regarding Dosti.
What is your grounds of objection taken? Why do you need the owner?
Owner is necessary because there was no policy, let's say. There was no policy.
Then if you are not able to effect service, is directed to take steps upon the response by way of registered individual. In addition, is directed to take steps by way of Dusty. When did you take steps by way of Dusty?
In Dosti service, let's say, I took step on 2/9/2024 and today I informed that that was affected. I have to file a affidavit, let's say.
No. You have to pay. There was a direction to take steps by way of Dusty. Dusty means there you have to put a date. You cannot file an affidavit later on. If the affidavit, if you don't file it on that day, matter goes. It seems that the steps have not been effected upon the respondent number 1 and 2 in spite of a passage of a decade. Full stop. A last opportunity is being granted to the appellant to effect service upon the respondent number 1 and 2 by way of Dusty, routed through the registry of this court and file an affidavit of service on or before the next date. List the matter again on 21st of July 2025. Full stop. It is observed that if no steps by way of Dusty is effected, this court shall pass appropriate orders.
19,
Affected by an affidavit is not filed, this court shall pass appropriate. Yes, who is appearing?
item 19,
None appears on behalf of the petitioner on call when the matter is taken up, taking into account the above, this court, it appears that the petitioner is no longer interested in the instant proceedings. Accordingly, the instant proceedings stands dismissed for non-prosecution, the interim order passed on 26/6/2019 by which further proceedings of FC number 352/2019 was stayed is hereby revived, and the court of the learned Principal Judge Family Court Kamrup Metro at Guwahati is directed to proceed with the proceedings being FCC number 352/2019 in accordance with law, the registry shall duly inform the learned court about this order.
20,
What is this?
Your Honor, service upon respondent 1 and 2 is completed.
Where about service? I'm not into service. Now, first of tell me what is your case? What you are challenging?
Your Honor, the impugn order is in page number 30.
31.
30.
30?
And
Here is the last affidavit. 31. 19/8/2019.
Yes.
And the
Your Honor,
petition under section 9 stating that we are instituted a suit for claiming interest and so and so. The plaintiffs filed the suit for declaration in adverse possession, confirmation in adverse possession for physical except I do not find any merit. You're challenging this order of 19.8.
Yes, sir.
So, what is wrong?
Your Honor, I've challenged the maintainability of the petition filed by the respondent side in the,
Maintainability of the suit.
yes. So my petition was
The
rejected.
suit is being filed for asking for what? Plaintiff's right, title and interest and adverse possession may kindly be declared. So his claim is on adverse possession. How can it be gone to the under the Assam Temporarily Settled Area Tenancy Act? No case. Lago, heard Mr. So-and-so.
Lordship,
I'm dismissing his case.
Yes, my
Then
lord.
Take your seat. Mr. You know case. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner and Mr. M. Talika, who appears on behalf of the respondent.
I will respond on one.
Have challenge invoked the supervisory jurisdiction of the court challenging the order dated 19/8/2019 passed in Mizi case number 543/2018 arising out of title suit number 494/2017 Pusto, whereby the said application being Mizi case number 543/2018 was dismissed. Pusto. It is the case of the petitioner herein that the suit was not maintainable in view of the provisions of the Assam Temporarily Settled Areas Tenancy Act 1972. Inasmuch as the plaintiff was required to seek relief under the said provisions and not by way of filing of a suit. The learned trial court by the order impugned order dated 19/8/2019 had rejected the said petition, taking into consideration that the suit so filed by the plaintiff was a suit based upon claiming right, title, and interest on the basis of adverse possession. Adverse possession. And as such, the said application was not maintainable. This court finds no ground to interfere with the impugned order dated 19/8/2023 passed by the learned trial court, for which the instant petition stands dismissed. Interim order is there. This court further. It is further seen that by the order dated 29/2019, the further proceedings of title suit number 494/2017 pending before the learned civil judge, senior division number 2, Kamrup Metro at Guwahati was stayed. The said stay order is vacated and the parties herein are directed to appear before the learned court of the civil judge, senior division number 2, Kamrup Metro at Guwahati on 23rd of June 2025 for further proceedings of the suit.
21.
There is a reported Dagan also.
Oh, very well.
I am filing the also affidavit of those.
Don't file. I've dismissed.
Already filing.
Oh, very
May please, your lordship. I'm sorry, lordship. Earlier, we took.
Item number?
21, your lordship.
What happened?
Earlier, we took steps by both ways, but that was not effected.
What is your case?
Lordship. The case is at the impugned order is at page, your lordship, 60.
Page 60.
My petition for substitution was rejected, your lordship. Although the defendant did not have any objection.
Then? What is
Lordship,
wrong?
Actually, lordship, the date that was not submitted by the defendant's counsel, and the petitioner did not know the date.
Now you know?
Yes, I have.
Now you know or not?
Yes, yes.
Heard Mr. Yasom, the learned counsel appearing on behalf of the petitioner. The supervisory jurisdiction of this court has been invoked, challenging the order dated 29/7/2022, passed in petition number 1502/2022, dated 31/5/2022. arising out of title suit number 07/2000,
19,
suit number
2007 of 2019.
2019. Mr. Yasom, the learned counsel appearing on behalf of the petitioner, submitted there was an inadvertence on the part of the learned counsel, on the part of the petitioner not to file an application under Order 22(9) as well as Section 5 of the Limitation Act, along with the application filed under Order 22 Rule 4 of the Code. The learned counsel submits that on account of this inadvertence happened on account of the ground that the petitioner was not aware of the date of death of the defendant number 2. He therefore submitted that this period, that taking into account the judgment of the Supreme Court in the case of Om Prakash Gupta versus so-and-so reported in so-and-so, the petitioner would be well advised to file an application before the file a proper applications before the learned trial court, and the learned trial court may be directed to consider the same. This court further takes and he further submitted that the period during which the instant proceedings have been pending be excluded while computing the period of limitation in filing the said application. So taking into account the order dated 29/7/2022 passed, which have been impugned in the instant proceeding, then this court have given a due consideration of the materials on record, and have also heard the learned counsel appearing on behalf of the petitioner. It is also seen that the respondents are not represented. Taking into account the said submissions made by the learned counsel appearing on behalf of the petitioner, this court closes the instant proceedings, thereby giving liberty to the petitioner to file an application for under Order 22 Rule 9 as well as Section 5 of the Limitation Act for condonation of the delay before the learned trial court. This court further observes that the period from 24/8/2022 till date be excluded while computing the period of limitation in filing the application under Order 22 Rule 9 of the code. This court further observes and directs that upon such application being filed, this court further restores the petition number 1502/2022, taking into account that the same would be required for the purpose of substitution of the legal heirs of the defendant number 2. So considering the above, this court further directs the learned trial court, that is the court of the civil judge Hunitpur at Tejpur, to consider the 3 applications without being influenced by the order dated 29/7/2022, taking into account the settled position of law as held by the Supreme Court, the Constitution Bench of the Supreme Court, in the case of Sardar Amarjit Singh versus so-and-so, reported in 2003 3 SCC, wherein the Supreme Court observed that the provisions of Order 22 are for the purpose of continuation of the proceeding and not for culmination on merits.
22.
We have taken steps and official.
Who is respond number 3?
Number 3, yes. 4 received, but 3 not received.
Who is respond number 3? Owner.
Yes.
And you are asking for enhancement.
Enhancement and also share of the awarded amount.
Enhancement against whom?
Where
Where is the decree? Decree is given to him. Payment Why do you need the other side?
No.
Why do you need the response number 3? Taking into account that that response number 3, the appellant you have not challenged. So the liability is yours.
Yes.
Liability is yours. So we remove the response number 3, not necessary. The appeal can proceed. If there is an enhancement, the liability is yours. You have not challenged the liability.
So earlier he was a party, so may not come to me. In the trial proceeding, he was
Good.
party.
Good stuff. This court have duly taken note of the office note dated 35/2025, wherein it is mentioned that the service of upon the response number 3 is not complete. First of this court further takes note of, they have also taken note of the judgment, impugned judgment and award dated 24/8/2022, passed in MSC case number 203/2016, whereby the learned court of the learned member MSCT Gwalpara had imposed, settled the entire liability upon the United India Insurance Company, who is the respondent number 1 and 2 in the present proceedings. First, taking into account the presence and taking into account that the respondent number 1 and 2 have not filed a counter appeal in the instant proceedings. Thereby, it is the opinion of this court that the instant appeal can be proceeded with in absence of the respondent number 3. Accordingly, as the other respondents are duly represented, the instant appeal will be listed for hearing. Liberty given to both the parties to file application for early hearing.
That's for number 5.
Put your names. We'll put it in good.
53,
Who is being for response number 1?
Your Lordship, as per office note dated 27/5, unserved notice upon respondent number 1. Lordship. Service is not complete upon respondent number 1.
That I know. Who is response number 1? Any idea? Is there? You could have said that.
Subhash Sharma, Lordship. The vendor,
Next week.
the instant petition.
Stop. This court have duly taken note of the office note dated 27/5/2025, wherein it has been mentioned that the addressee moved and returned to the sender. So taking into account the above, the appellant is directed to effect service upon the respondent number 1 after ascertaining the proper address within 16th of June 2025. If such steps are not taken, the matter be again listed before this court.
24,
Please, Your Lordship. Your Lordship, as per office note dated 27/5/25, the answer notice has been received with the postal endorsement insufficient address.
What do you want to do?
Your Lordship, I may be allowed to take fresh steps.
The learned counsel appearing on behalf of the petitioner submits that taking into account the office note dated 27/5/2025, he may be permitted to take fresh steps upon the respondent, sole respondent, after ascertaining the proper address. So taking into account the petition appellant is given the liberty to take steps, directed to take steps on the proper address on or before 23rd of June 2025. Thereupon the matter be listed.
25,
Yes, Mr. Moloskar.
The hostage service has been effected upon the respondent number 5, 6, and 7. As per direction of this one.
Delay?
Yes, delay.
How much?
101.
101.
101.
Yes, are you objecting?
Well, I am objecting.
Are you sure?
Yes, ma'am.
Why?
And the learned Court of Appeal below dismissed the appeal on merit, although the appellant was absent. The appellant was absent. Against that, they have preferred this appeal. There is a delay. I am opposing the delay on the ground that the conduct of the appellant is such that before the trial court, they filed the suit challenging certain sale deeds in my favor. And for several days, they have filed evidence on behalf of only one of the witnesses, PW1. And several occasions they have taken time, and ultimately he did not turn up for cross-examination. Then, because of absence of any evidence on the part of the plaintiff, the suit was dismissed. Then they preferred an appeal. Appeal remained pending for several years, 5 years. And in the appeal also, my lord, ultimately they did not appear, and the appeal was dismissed.
Appeal was dismissed for default?
It was not
On
dismissed for
merits,
default. It was
on merits.
on
My
merit.
lord,
How?
Your lord,
this is the main issue there, my lord.
How?
correct, my lord. It should have been dismissed for default. It's very clear. Now, the present appeal, there is again delay. Lordship will kindly see what is the ground they have taken. And I am opposing it because, my lord, the persons who are preferring this appeal, they are not residing here. Right from the beginning, their stand is there, they reside in Bangladesh. They reside in Bangladesh. Now, what has happened, my lord? They are pursuing this for the purpose of protecting the tenant they have. Initially, there was a tenant. Against the tenant, there was an ejectment suit. Suit was decreed, appeal was dismissed, revision was dismissed. Then now they have filed some application before the executing court that they are going to obtain some stay from the Supreme Court. Until 7th of July, they have taken time from the trial court. And same property. And in this suit, they don't have anything, but they want to file an appeal so that it is there, the tenant is protected. Now, tenant has left long back, my lord. One political party, or SUCI political party, I have given a picture in my affidavit of this, my lord. There's a political party which is organizing, occupying the tenanted premises. And they are the persons who are actually pursuing the whole case.
They are my tenants.
They cannot be their tenant because against the tenant, there is a decree. So if any subtenant is there, he will be bound by the decree.
Mr. Muzumdar, let us condone the appeal delay.
I mean, if your lordship considers the
No,
delay,
wait. Admit frame the substantial question of law.
Right.
Have it on Wednesday,
Right.
remand the appeal back
Yeah.
for decision within 30 days.
that your lordship can do. If your lordship is the
I
same-
can't do that on the first day. All,
then
I
next week-
can't do it.
That is the
Because
other
the appeal
alternative I
has
was-
not
I
been
agree with
numbered.
proposal
that
of
is the other alternative which I was thinking. Then your lordship will give them a time frame of 30 days
Yes.
to the court below, my lord. Because otherwise,
It is what,
the whole
so
purpose.
first I have to
I am
condone.
we will find-
I can be very, if you want that we should also be very strict in condonation of delay, we can be. We'll take it as and take it very seriously. This, and whenever all matters appear, we will be very will apply the same yardstick, because otherwise you may also say, then
not because
that this court has been not fair in respect to one of my clients, and the other client has been very fair.
But here I am on, not on the ground, they, explanation they've given, because of the conduct, my lord. One political party is now
Till
occupying my.
300 days, I don't touch. Let them have the right. Thereafter, after 3 days,
My lord,
I work up.
my lord,
I think the best option is admit the appeal.
my lord.
This thing. Direct them to register it on Monday or Wednesday.
Yeah.
Wednesday, I frame the issue. Friday,
Right.
appeal disposed.
With
That.
that, with what, 30 days. I agree.
Let
Well,
them
that is
argue.
that is the other option I was also
That
thinking.
seems to be the win-win for everybody. Okay, this is an application filed under Section 5 of the Limitation Act, seeking condonation of delay in preferring the accompanying appeal against the judgment and decree dated against the judgment and decree dated
30th September 2022.
39/2022, passed in title appeal number 4/2017 by the learned district judge Karimganj. Pustak. This court have duly perused the grounds which have been stated in paragraph number 8. Nine, 10 of the application. This court have also perused the objections so filed to the said application. Pustak, taking into account the grounds which have been stated in paragraph number 4 to 10 in the opinion of this court are sufficient, are come within the ambit of a sufficient cause for condoning the delay of 101 days in preparing the accompanying appeal. Accordingly, the appeal stands, accordingly, the instant application stands admitted. Pustak. It has been submitted at the bar by both the counsels that the matter requires an urgent disposal, urgently to be taken into account. Taking into account, the registry is directed to register the accompanying appeal and list this matter in terms with Order 41, Rule 11 before this court on Wednesday. I stands disposed.
Can it be on Monday?
Wednesday. This Wednesday.
Or this Wednesday?
We'll frame. On Wednesday, we will frame the substantial question over. Friday, appeal disposed. You can't get a faster.
No, I was paying for Monday 9th.
Why do you need it? That is the substantial question of law. We'll frame it on Wednesday. Friday disposed. Holding it.
Wednesday and Thursday, I put some difficulty. Wednesday and Thursday, that is why I'm saying.
Huh?
Wednesday and Thursday, I put some difficulty.
You don't require, in fact, I'm not to hear you also. You appear on Friday.
Yeah.
26.
Obliged.
My goodness. Appeal, why?
My lord,
Has been received and tagged with the Imam of Palatman. Everything is appearing. With the service being complete, please matter for hearing in the usual course, liberty given to both the parties to file application for early hearing.
27.
Yes, you want it, John, sign it there?
No, Lordship, here.
Tell me.
We have not yet received the dusty
Huh?
service, Lordship. Dusty service, so we could not.
Service done or not, Dusty?
We have informed the insurance company, but we have not yet received the.
Okay, again, sign it there.
I am appearing to respond.
You've seen that the steps, respond number? You've seen that the steps have not been taken by the appellant
1 week time may be granted.
by way of Dusty, in spite of there being a direction passed by this court on 17/3/2025. Stay is there.
Lordships,
We will get the stay.
stay is not there, Lordship.
There's no stay.
Lordship, if
Taking into account the steps having not been effected, comma, it amounts, the appellant has been delaying the disposal of the appeal.
no, Lordship, we have informed. In fact, I have the paper also.
accordingly list the matter after
2 weeks.
service is complete upon the respondent number one. Full stop. As there is no stay to the judgment and award dated 10/1/2023 passed by the Commissioner Employees Compensation Nagaon, Assam, the claimant shall be entitled to proceed with the execution of the said amount or of the awarded amount as per law.
28.
May I please, your lordship?
Tell me.
As per order dated 22/8/24, Honorable Supreme Court has set aside the order of this honorable court. So we are going to review in this regard.
Lordship, I have that order.
What happened?
Order is.
Lordship,
Is the
by way of the
confirmation
civil
delay.
division, Lordship, they challenge the judgment dated 9/5/2011 passed by the civil judge Tinsukia, Lordship. And there was a delay of 4,037 days, for which they filed a delay condonation petition that was allowed by this honorable court, Lordship. That
it?
was
Where is it?
It's IA number.
IA number 3156 of the
3156.
2022.
This was allowed.
It was allowed. We filed a SLP before the Honorable Supreme Court, and that order has been set aside, Lordship.
Okay.
As on date, they do not have any case, Lordship.
So we are going to filing a review petition.
That is,
I can't help you. Full stop.
2 weeks time is given.
Full stop. The instant revision petition is directed against the judgment dated 9/5/2011 passed by the learned civil judge Tinsukia in miscellaneous appeal number 7/2010, whereby the order dated 23/2/2010 passed by the learned Munsif number 1 Tinsukia in MZ case number 35/2009, refusing to set aside the ex parte order. Full stop. The delay in preferring the instant application was 4,037 days, for which an application was filed being IAC 3156/2022. Full stop. The said application was allowed by the learned coordinate bench of this court by an order dated 22/8/2024. Full stop. Being aggrieved, the respondent herein had preferred a
SLP number.
special leave petition before the Supreme Court. Full stop. Full stop. The Supreme Court, upon converting the special leave petition being SLP bracket C number 27360/2024, upon granting leave in special leave petition SLP bracket C number 27360/2024, which was renumbered as civil appeal number 5203/2025, dismissed and allowed the said appeal, thereby setting aside the order dated 22/8/2024 passed in IAC number 3156/2022. First, taking into account the above, therefore, the instant revision application is barred by limitation, for which the present revision proceedings cannot be proceeded with according. the revision petition stands.
29,
Your Honor, as per the Honorable Court's last order, we had taken steps upon respondent 3 to 5. And neither AD card nor unsub notice has been received yet by this Honorable Court.
You are appearing for?
It is
1, 2, 6 and 7.
What about three ABC?
PABC, we have sent notice.
The
but
last
this was not
occasion,
received.
3 was substituted, Lordship.
Neither AD card nor served upon, on the respond number 3 to 5. Service not complete.
Service not.
What is the matter about?
There is an impugned order page 45. On the 90th day of filing the written statement by me, I had filed a petition under orders 7 rule 11, read with 151 with a prayer for rejection of the plaint. The Honorable Court and also a petition for keeping.
Yes, you have a case. You got a notice from me. That is enough. So the problem is not serving three ABC. How do I do it? Tell me.
To the Honorable Court, whatever the court says. Whatever the Honorable Court says, maybe it's just that.
Oh, only thing I can do is dismiss your petition, then it becomes easier. If you want that.
Press steps.
Did you file the fresh memo of parties?
Yes, yes, Your Honor.
Why you're not able to serve these people? They are residing in Guwahati. Then?
We've taken steps, Your Honor.
Serve these people by way of Dusty. The Landlord Council appearing on behalf of the petition. You are appearing for whom? 9. There is no 9. Oh, I said 9. Oh, 9. Okay. Anybody in relation with these people? 3 ABC? No.
No, Your Honor.
Okay. The Landlord Council appearing on behalf of the petitioner submits that he may be permitted to effect service upon the respond number 3A, 3B, 3C and respond number 4 and 5 by way of Dusty. So taking into account the above, this is matter again on before vacation, 27th of June 2025, interim, the petitioner is directed to effect service upon the respond number 3A, 3B, 3C, 4 and 5 by way of Dusty routed through the registry of this court and file an affidavit of service before the next date. The interim order past relation. This is a very small thing. Why are you finishing it off? You are the
item 30,
defendants.
Thought you about High Court, Lordship.
What does it say?
Yes, it says. Order 8 rule 1 time for filing written statement. Trial court keeping in abeyance the filing of written statement pending disposal of application filed under order 7 rule 11 property held. The time for filing written statement cannot be extended beyond 90 days by excluding the period of time taken in disposal of application for rejection of.
When is the judgment?
2005 supply GLC.
There are the problems. Of the Supreme Court?
No, our High Court.
They are the problem. This is before that Kailash versus Nanku and all. And this judgment also does not take into account the judgment of the Supreme Court in 2003,
Yes,
8 SCC.
Yes, yes.
Wherein it says that is
But
not
a portion was, a portion of the judgment was considered. The portion was that while disposing a petition under order 7 rule 11, only the pleadings of the plaintiff is to be.
And as such, the question of the written statement has no relevance.
Yes.
That is the judgment.
That part was considered by this honorable.
It's okay, but you see, it's on the 90th day. On that day, this court could have exercised 148A also could have done it, 148. Then also, we need to do something out there and finish up. Commercial, it's a different thing.
Yes.
But because of this, it is getting delayed. Na? Affect your service. And 25,000 is the cost. Get that also. Yes, Mr. Gusami. What is this item number?
I think paper publication seems to be the only way out. The owner of the vehicle has shifted from Bishnath side to Guwahati. Paper with white.
Mr. R. Gusami submits that he would file an appropriate application seeking paper publication. Taking into account the above list this matter upon filing up such application.
31,
What are these?
These IAs have been filed by the respondent, my lord. One for reducing additional evidence and the other for correction of the cost item. Your lordship will.
Reducing secondary evidence has to be taken at the time of appeal. We have no business on that. You have filed objection. And the other is?
Other is for amendment of the cost item.
Amendment of the cost title. What has happened?
My lord will recollect your lordship had heard this matter once, my lord.
Oh.
Otherwise, everything is in order, just the fact that the appellant was an association of persons.
You have filed objection?
They filed their objection. We filed the application and now they filed their objection today. My lord, it was an association of persons shown to be represented.
Oh, we have to take these together.
Together probably would be better.
Okay, taking into account that both the interlocutory application can only be disposed of along with the appeal, comma. Along with the appeal, comma. List the appeal for hearing on 15th of July.
15th of July. Can it be after 18th?
Very well. Have it on 22nd of July. 22nd of July.
32,
Can it be 24th?
No. If I have to take it, no.
15th.
No. 15th it is okay. 22nd, 29th.
29th. 29th. Deeply obliged.
Yes.
So
Service?
service has been effected, my lord, by way of the stay upon the sole respondent.
But service, has he, where's the affidavit of service?
Yes, affidavit will be filed on 29th.
Has he received it?
Yes.
He has not appeared.
No, my lord.
Taking into account that the service, this court have duly taken note of the affidavit of service profile. And deems that the service upon the respondent is complete. Full stop. Accordingly, this. Accordingly, however, as the respondent is not represented, full stop. This court grants a final opportunity. This court fixes this matter again on 11th of June 2025. So it is observed that if the respondent is not represented on the next date, this court shall proceed with the disposal of the transfer application in his absence. So interim order passed earlier on 5/5/2025 shall be then extended till the next date.
33,
What is this?
Lordship, our CRPIO was dismissed for non-prosecution, Lordship. My name was not shown in the cause list, so we could not appear, Lordship.
It is dismissed?
Dismissed for non-prosecution, Lordship. I have
Where?
CRPIO, Lordship. Order, Lordship, on page 12, Lordship.
None appears on behalf of the petitioner on call 54/2025. Where? I tell you, what is the case number?
The CRPIO, Lordship, 121, Lordship. Of 2000.
Espegu. Who is Espegu?
Lordship, he is my junior, Lordship.
Then?
Lordship, he searched his name, Lordship.
Huh?
He searched his name, but it was written, Lordship. In Espegu, he did not find it. On S.Pegu, it is fine, Lordship. So he was searching on f.pegu.
Then,
But f.pegu,
No,
in
those-
f.pegu it was not found, Lordship. Only in f.pegu, it is there, but he was searching in s.pegu, Lordship.
there is an application filed under Order 9, Rule 9 for restoration of the accompanying revision accompanying application under Article 227 of the Constitution on the ground that Mr. Espegu, on the ground that the name of the council, Mr. A.J. Saikia, was not shown in the cause list for which he missed it. Full stop. Taking into account, this court have duly perused the Wakalatnama wherein it is seen that the name of the appellant have been, name of the appellant, a petitioner have, wherein it is seen that Mr. A.J. Saikia along with two others have signed the Wakalatnama, but the name of only Mr. S. Pegu has been signed, shown in the cause list. Considering the above, it is the opinion of this court that the order dated 34/2024/25 passed in CRPIO number 121/2025 is required to be recalled accordingly. This court allows the instant application, thereby recalling the order dated 34/2025 and restores the accompanying petition being CRPIO number 121/2025 to the file of this court. I stands disposed, CRPIO, Lehibo. In view of the order being passed in case number 23/2025, the petitioner is directed to effect. Oh, this is a notice only.
Yes, Lordship. It is, not- Okay.
In view of the order passed in this case number 25/2025, 23/25, list the petition for motion next week.
Also in CRPIO, Lordship, my name may be shown, Lordship. Otherwise, I may again miss, Lordship.
34,
Vijay Soikia along with two others who have signed the Wakalatnama be shown in the cause list by the registry.
Service report awaited, man.
Service why not complete?
Awaited, man. Report awaited.
Huh?
Service report awaited.
Why haven't you taken dusty service?
The dusty service, my the client informed me that his relation is not good.
Taking into account that there is no dusty service being taken in spite of an order being passed, this court vacates the order dated 14/5/2025. List the matter after completion of service. The registry shall duly intimate the learned court below about the order being passed.
35,
On the last occasion, Lordship was directed to take dusty service apart from visual and registered post. And I have taken the dusty service, but they have refused to accept it. To that effect, I have filed one affidavit, paragraph 2.
Affidavit filed.
Affidavit filed.
What happened? They did not accept.
Did not accept.
The addressee not available. Usual process has not been received. First. It is seen that this court have duly taken note of the affidavit of service filed on 23/5/2025, wherein it has been duly mentioned that the petitioner had approached the respondents. Respondent, na?
Respondents 1 to 4.
1 to 4, but they refused to accept. That too in presence of the witnesses. So taking into account the above, the service upon the respondent number 1 to 4 is deemed to be complete. List the matter for admission on 21st July 2025. Interim order, interim order. is there,
No,
na?
no interim.
Oh, then we should have it early. What is this case for?
But application under order 21, rule 99 was filed by the respondent number
2 and 3, who are not the judgment debtor. And even in their petition under Order 21, Rule 99, they have never stated that they have been dispossessed while executing the
Okay, taking into account the above, list this matter again on 16th of June 2025 in the stage of admission.
Good.
You dispose it on that date?
Yes, always.
36,
Happy.
Hmm.
Your Lordship, due to certain inconvenience on our part, we have taken steps only through usual process, Lordship. So kindly
Ah.
to its,
Service complete?
no, Lordship, we have taken steps
With
only
regard
through
to the
usual
notice
process.
issued by you and further steps for issued for the demand. You have not taken steps by way of trustee as well as the, yeah,
So Lordship, to
taking into
stand,
account that no steps have been taken by way of trustee as well as by registered court, it seems that the petitioner is not in an urgency. List the matter after completion of service upon the respondents.
37,
Take up the matter on 16th of May.
Huh?
16th of May, my lord.
Ah.
My lord, you just take up the matter.
Oh, yes.
Yeah.
What is this business of going on, all these things, arguments and all? This is at the stage of, yeah. This is the case where you have moved it unlisted, if I remember correctly.
Yes, my lord.
Wherein you said that there
No, tenant,
some will, some probate
Yes,
judgment,
yes,
they
ma'am.
wanted to place it.
yes,
And then they are going on cross-examining and now examining
on probate, my lord.
on probate. which
On
is no
probate.
business. What is this?
Is absolutely, if your lordship kindly have a look at the WS, it is the admitted fact that they are my tenants.
Now, what is this, all these things? What is going on?
Otherwise, the matter has been fixed for objection, Lordship.
What?
The next date has been fixed for, on 6th for objection, filing their objection, Lordship.
What
On the
objection?
petition filed by us for calling for the records, the impugn order that they have been challenged, they have challenged for calling for the records from the additional district and session.
The
So
probate
that
process.
is for that probate record, Lordship. And that is fixed for objection.
No, are you denying that they are not your landlord? Then what is this probate business? This can't go on like this.
The lordship kindly, I just
Shocking.
lordship will just have a look of the entire matter, my lord. Lordship will shock that this 2015 matter, they filed by
29/3/2025. The court heard on it and appeals that the court had discretionary for permit withdrawal of within even after the closure of Iman. And so further, the plaintiff shall complete the cross-examination of Iman without seeking any adjournments. Thereupon, PW1 is present, defendants are here fixed for cross-examination. This is a harassment. What is wrong with this?
and the court has permitted the cross-examination, my lord. If your lordship kindly have a look at the cross-examination, it is absolutely abuse the process of court. Pure landlord tenant case, my lord, is converted to a regular suit. The only issue is whether the defendant is the defaulter or not, issue number 2. That is the only issue. I am submitting the issue here in notes. And if your lordship has a look at the cross-examination permitted by the land trial court, lordship, kindly have a look at the cross-examination for a moment, my lord.
Now, what has happened on 3/5?
On 3/5, my lord,
There was a
they
function.
filed their application to call for the probate proceeding. And
It was allowed.
no, it is pending for the consideration, but it will be allowed because once the court has allowed for cross-examination on the probate, then naturally record is required in the opinion of the court. And enter in spite of our objection.
Are you going to appear in this matter or you senior? You are appearing. I'm passing strictures upon that court. This is not done. Never heard of this type of things going on. Which judge is this? Division, junior division.
Two.
Huh?
Yes. One Mr. Fukun is there.
You have given your evidence? No.
No, what happened, my lord? 7 long dates, 7. On 7th occasion, I am putting up myself as a cross-examination. Then the cross-examination is over finally on 19/7
Of?
of 2024.
Okay.
It is
then-
started in 2019.
then-
Its comments from, Lordship, can we have a look? It is comment from 22/11/2019 and is concluded on 19/7/2024.
Then
Thereafter, 3 dates were fixed for the defense evidence. On the third date, that is on 26/9/2024, they filed this application for recalling the PW1. And so far the probate case is concerned, they cross-examined me, my lord. In earlier occasion.
Huh?
In earlier occasion, the defendant's counsel has cross-examined me on probate proceedings.
you have challenged the 29(3).
No, that's a problem, my lord, with me, because we are submitted ourselves to the cross-examination with a view. There's a very short 1-day occasion, my lord. But it appears that it will continue for years now. Their application is very specific, that the judgment has pronounced, so this is a subsequent development, so we will cross-examine on that part. The learned triad court also, while allowing, also specific the no further adjournment and only the subsequent development. But that's also appears to be not good, my lord, because probate proceeding, what is with the landlord tenant case? They filed 2 counterclaim, my lord, in 2 occasions, which was rejected.
Mr.
Lordship's judgment already circulated, my lord. Lordship's judgment of February 2024. But I must say, my lord, so far the Dibrugarh and Dikshogi in concern, that judgment is not followed. I just draw the attention of this.
Mr. B. Dotto, the learned senior counsel assisted by Mr. S. Teka, appearing on behalf of the Mr. Also appears for the respondent numbers 1 to 4. The learned senior counsel appearing on behalf of the appellant. Submits that the present proceedings under Article 2 to 7 of the Constitution have been invoked in order to place before this court the gross abuse of the process of the court, whereby a landlord-tenant dispute have been converted to a suit based on title. The learned counsel submitted that the petitioners herein as plaintiffs had instituted a suit against the respondents herein. Which was registered and numbered as title suit number 37/2015. The said suit was filed for recovery of vacant and cast possession of the suit premises on the ground that the defendants are defaulters in payment of rent. From the month of January 2015 onwards. The learned senior counsel drew the attention of this court to the written statement filed by the defendants in the said suit.
Page 42.
Wherein the defendants have duly admitted at paragraph number 16 and 17. Paragraph number 16.
And 18, my lord. Third paragraph. Last paragraph.
16 and
18, my lord.
and 18,
Yes.
wherein the defendants claim that the plaintiffs had, by their letter dated 21/4/2010, intimated about the transfer of ownership, annexing the document of title, and after a few months received the rent for several months together without issuing proper receipt. And that the defendants have duly attorned to the plaintiffs as the landlords. The learned senior counsel further submitted that on the basis of the said pleadings, therefore, the learned trial court on 24/6/2019
Page 4.
framed as many as 6 issues on the ground, and primarily on the ground of as to whether the defendants are defaulters in payment of the monthly rent to the plaintiff on or from the month of January 2015. The learned counsel, senior counsel further submitted that the examination in chief of the plaintiff witnesses were duly filed on 30/10/2019. And thereupon the cross-examination of the plaintiff witnesses started with effect from 22/11/2019. After a passage of 5 years, the cross-examination was completed on 19/7/2024. Subsequent thereto, the case was fixed for defendant's evidence on
Is fixed for 12/8/2024, my.
12/8/2024. First, after taking 2 dates to adjournments on 26/9/2024, the defendants filed an application under Order 18, Rule 17, read with Section 151 for recalling the PW1 for further cross-examination on the ground. Where is that petition?
Petition is page 102,
On the ground
para 5.
that a judgment has been delivered on 13/8/2024 in titled probate number 130/2014. And as such, there is a requirement for re-examination for recalling the PW1 for further cross-examination. This court have duly taken note of the application which was filed under Order 18 with 17 read with Section 151 of the code. But there is not a single mention therein as to how the said judgment passed in title suit bracket probate number 130/2014 has relevance to the suit in the application. Be that as it may, the learned trial court, by an order dated 29/3/2025, exercised the power under Order 18, Rule 17, and recalled the PW1 for further cross-examination with respect to the subject matter of the instant suit entitled suit probate number 130/2014. First, thereupon, it is seen that on 24/4/2024, the PW1 was again present, but there was no cross-examination carried out. Again, on 3/5/2025, cross-examination was carried out of the PW1, and further cross-examination has been reserved. It is further seen that thereupon, it has been further submitted that thereupon, another application is now being filed by the defendants seeking the records of title probate, misprobate case number, title suit probate case number 130/2014. And as such, the suit, which is already a decade old, is further being delayed. It is under such circumstances the learned senior counsel submits that the supervisory jurisdiction of the court is required to be invoked so that the further abuse of the process of the court perpetuated. I've also heard the learned counsel appearing on behalf of the respondents and inquire as to what relevance there is of title suit probate number 130/2014 to the suit pending disposal, to the suit landlord tenant dispute pending vis-a-vis the plaintiff as well as the plaintiffs as well as the defendants.
This, this subject matter of this is also a subject matter of probate.
The learned counsel submits
The land.
subject matter of title suit probate number 130/2014 is also the subject matter of the present proceedings of the suit being title suit number 37/2015. First, this court have given an anxious consideration. First, and to the materials on record as well as the submissions so made by the learned counsels appearing on behalf of the parties. First, the materials on record as already reflected in the previous segments of the instant order clearly show that the plaintiff's suit is purely a suit for landlord for eviction of the tenants on the ground of default made in the payment of rent. The reference herein above made in respect to the written statement also goes to show that the plaintiffs have duly atoned to the plaintiffs, the defendants have duly atoned to the plaintiffs as their landlords, and also stated that they are not defaulters. On the basis thereof, the issues have been framed, including the issue number 2, which issue as to whether the defendants are defaulters in payment of rent. The record further reveals that the plaintiff have already adduced the evidence, and at the stage after taking two adjournments, the defendant has come up with this plea for recall of the plaintiff witness number 1 on the ground that there is a judgment passed on 13/8/2024 in title suit probate. Title suit probate number so and so. Title suit probate number 130/2014. First, this court have duly perused the said application, and there is nothing mentioned as to how the said title suit probate number 130/2014 has any relevance to the present suit being title suit number 37/2014. This court further have also perused the order dated 29/3/2025 passed by the learned trial court, and it shocks and surprises this court as to that the learned trial court have exercised the jurisdiction under order 18 rule 17 in such a casual manner. That too when the Supreme Court has been clear in various judgments of the Supreme Court, in the various judgments, including the case of K.K. Velaswamy versus so-and-so reported in 2011.
It is 2011 SEC 275.
This court have also taken note of the cross-examination so carried out. Part of the cross-examination so they carried out on 3/5/2025. And it shocks and surprises this court in the manner in which the cross-examination have also been permitted. Taking into account the above in the background of the above factual aspects, it is the opinion of this court that allowing the suit to proceed in the manner by which the learned trial court have permitted is in gross abuse of the process of the court. First, considering the above, in order to prevent the further abuse, in order to prevent the perpetuation of further abuse of the process of the court, as well as also the unnecessary judicial time being spent on unnecessary judicial time being expended, in having no relevance, it is the opinion of this court that this court, in the opinion of this court, that the order dated 29/3/2025 is required to be interfered with. Required. And the further continuation of the suit in the direction so made on the basis of the order order dated 29/3/2025 has also to be stopped. Accordingly, this court therefore disposes of the instant petition with the following observations and directions, comma. The order dated 29/3/2025 passed entitled suit number 37/2015 is interfered with. Full stop. The petition so filed by the petitioner by the defendants under Order 18, Rule 17, read with Section 151 of the Code of Civil Procedure, being petition number.
No.
958 of 2024 stands dismissed. The learned trial court, number 3, the learned trial court shall be directed to pursue with the suit. Is directed to proceed with the suit by permitting the defendants, the defendants to adduce evidence. And the further cross-examination, and this court further that the learned trial court, that is the court of so-and-so, is directed not to further proceed with the cross-examination of the plaintiff witness number 1, taking into account that the order dated 29/3/2025 has been interfered with. Next, the learned trial court further is directed to proceed with the suit in accordance with law, thereby permitting the defendants an opportunity to adduce evidence as per law.
And endeavor to dispose the matter. I am not asking for the time limit because it cannot be now. But endeavor to dispose the matter is 2015 matter. So my lord, I leave it to them.
This court observes that taking into account that the dispute between the plaintiff and the defendants are landlord tenant disputes, comma, the learned trial court shall make an endeavor to dispose of the suit as early as taking into account its business, taking into account the business of the taking into account its schedule, taking into account the business of the court, shall make an endeavor to dispose of the suit at an early.
My grateful, my.
38.
Contempt case, what is this? Yes, what do you have to do?
It's a review matter, Your Lordship.
What is there?
Review actually in
Review for what?
Lordship, in a contempt case of 557/23, the opposite party has submitted status report saying that all the dogs have been, like the mutation have been done, but later when
Who has passed that order?
Your Lordship has passed the order, Your Lordship.
Me?
Yes, Your Lordship.
Is there an order of some annexure 1 of Justice Saikya?
Lordship, kindly come to page number 22, Your Lordship.
What?
Page number 22 of the
This
review.
is a delay petition, na?
Yes, yes, there is also a condonation delay, Your Lordship.
Which order are you asking for?
Lordship, we have filed a review along with that, we have filed a condonation petition, Lordship.
Order has been complied with.
Yes, but it has not been complied with, Lordship. Lordship can peruse the Jamabandi. Only one dog in the Jamabandi has been mutated in the name of the petitioner, but one other dog is there.
Issue notice, returnable forms. That's by the resolution.
Obliged.
39.
In case Lordship, we file an IA.
We'll be filing objection, madam.
Vacating the interim order.
Who has filed?
We file, responding. 2 weeks time may be allowed to file objection. On 18/3/2025. But if as per the report of the Nazir, they have vacated the suit premises. One third person came that we have obtained stay order from this court.
Who has filed this petition?
We filed it, we respond
For what?
for vacate, modifying the order dated
16/6/2023. Past
page
in
9.
I can put. It has been disposed.
Lordship, that is disposed of.
Then, oh no,
Intellectual property is disposed of.
then it's a case of review. List this application. Taking into account that the interlocutory application being ISC 1681 of 2023 has already been disposed by an order dated 16/6/2023. Mr. Counsel, why you are not asking for an early hearing?
Lordship, on last occasion, I prayed, Lordship suggested me to file application for.
So early hearing would be better.
Lordship,
Because this is.
yes, Lordship,
very
nothing is there in
embarrassing
the second.
also.
Lordship, may fix in the first week of June.
When do you want it?
On the first week of June.
Huh?
On 10th June, Lord. 10th June.
Actually, let it be after that 15th. 10th, I'll be not available.
17?
17?
17?
17 will do.
This is an application filed for early hearing of the file for vacating for modification of the order dated 16/6/2023 passed in. IAC number 1681/2023 passed arising out of RSA number 103/2023. This court have duly taken note of that the ISC number 1681/2023 has already been disposed of, and as such, the question of vacating the said order does not arise. Be that as it may, the learned counsel appearing on behalf of the appellant respondent submitted that the matter requires an urgent disposal. The learned counsel appearing on behalf of the respondent appellants have no objection to that. Accordingly, this the matter on 17th of June 2025 at 2 p.m. Liberty is given to the parties to mention the matter.
Yes.
Mr.
I have a small prayer, Lordship.
Yes.
An appeal was disposed on 23rd May, Lordship. The office is under attachment. I'm praying.
Which one?
This,
You want-
United versus Bonali Board, that was this,
I
disposed
passed
of.
an order.
Yes, Lordship.
Did
It's
not
not
come.
in online, Lordship.
There is not some
The
order.
office is under attachment.
Okay, I'll see to it.
I'll give this.
How do I बोला कि क्यों?